All right, y'all. We are live and the court hearing is not starting yet, but I just wanted to come on here and hang out with you guys. I don't know if I'm going to do the whole day, but I'm going to do the best I can. So everybody come on in, share this video out. We're going to hang out for a minute until the hearing starts. I got a lot of thoughts. I got a nice little synopsis for you on day 4. So this is day 5 of the Tyler Robinson court hearing. So everybody come on in, hit the like button, hit the like button, hit the like button. And speaking of hit the like button, we're going to start off with the like button song.
Everybody hit the like button. 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 If you got something to say, drop it in the comments. Don't be acting afraid. What? Everybody hit the like button. Everybody hit the like button. If you got something to say, drop it in the comments. Don't be acting afraid. Drop your city in the chat. Let me know you at. Drop your city in the chat. Let me know you at. Drop your city in the chat. Let me know you at. Drop your city. What? Drop your city in the chat. What? Drop your city. What? Drop your city in the chat. Drop your city in the chat.
All right. So what is your sentiment about how the case is going on like thus far? So 1, drop your city in the chat. Let me know where you at. 2, hit the like button. 3, make sure to hype the video if you see the hype button. But while you drop your city in the chat, also drop in the chat what you think about this whole situation. I was talking to the guys in the group chat and I was just like, there's no way in this world this whole situation goes out to a trial until yesterday. Can you guys believe that the one piece of evidence they have is Tyler Robinson's own boyfriend? Present boyfriend. Well, not present because he's in jail, but it's not like they broke up. So I want y'all to think about this. Imagine being in a relationship and y'all are living together and then you get accused of a crime that you did not commit and you go to jail. And then while you're in jail, your boyfriend or girlfriend, present boyfriend, present girlfriend, turns around and tells the police that you did it. Like, out of all people, why would your boyfriend or girlfriend say you did something, whether you did it or not? But in this situation, I don't think he did it. Because they're still together. Why are you testifying against your own mate? Like, who the hell does that? So, according to everything that I've seen, and we're going to break down some things because I love what Barron said and did. The only evidence that they have is his mate. So his own boyfriend is literally going to be the person that possibly gets Tyler Robinson unalived by the government. That is crazy to me. Okay, so let's break some things down. But let me know what y'all think in the chat. And just let me know what y'all think in the chat, because I want to see what y'all have to say, because it just blows my mind. So let's break down some things. Okay, I'm gonna go from back to front. Okay, so we all seen this, but even with Lance Twiggs seeing this. They literally said, okay, do you recognize that this is Tyler Robinson? And he said, kind of. And I'm like, you don't know your own boyfriend? If I sing a video of my girlfriend, how she walks, how she moves, I'm going to know her, because if she's my girlfriend, I'm going to recognize her the second I see her. So Lance is just like, it's fuzzy, but I think it's him. Huh? So let's go through this, and then we're just going to break down some things. It's absolutely crazy. Hit the like button, hit the like button, hit the like button, hit the like button. So we all know that that's not his car because of the sunroof, the lack of sunroof. And I'm going to show you. Actually, no, I'm just going to play this, and then I got something else. This is absolutely crazy. I feel so sorry for this boy, because it's like no matter what happens, he's not going to get off. So we're going to just run through all the evidence, and then we'll go from there. All right, so look at the sunroof. There's no sunroof. See right there, no sunroof. All right, so of course we talked about the limp. We're going to go through that a little bit. Oh, and everybody say good morning. I'm not really a morning person. So good morning to everybody watching, and everybody say good morning back. Say good morning back, because I am not necessarily a morning person. So good morning to everybody. So as you already know, blue book bag instead of black book bag. And I think this right here is Tyler Robinson, but I don't think the other person is Tyler Robinson. All right. And it walks out. So I don't think this is Tyler Robinson. I think the first person was Tyler Robinson. So and right here, Barron pointed out something that really blew my mind, because I didn't pay attention to it. But actually, I'll let Barron speak on it. Wait, what is this?
Just a nonsensical.
Oh, I'll get to that in a second.
We go through this evidence. I want you to ask yourself, is this a fair process? Is this a fair process? Because if the answer to that question is no, you should be horrified. You should be disgusted. You should be absolutely disgusted. But I do want to clear up a few things, because in the past, we have stated time and time again that Tyler Robinson was seen on campus by a police officer around 6:30 p.m. I'll show you that original article now. Wrong button. I'll show you that original article now. This says right here, this was a Fox News article. This is why we've been reporting this. It happened around 6:30 p.m. on September 10th, roughly 6 hours after a sniper's round struck Kirk in the neck as he was engaging the audience. The officer guarding the perimeter after authorities placed campus on lockdown. The encounter appears to have thwarted the suspect's attempt to recover the Mauser. Okay, so that's why we reported that. We report things based on the evidence that's in front of us. And then we ask the question, how could he be there at 6:30 and then in Panguitch at 8:45, because that timeline doesn't add up. So what's going on here? Well, we now know, because that was clarified in court. What actually happened, I'll show you the footage of it. This happened yesterday, is Tyler Robinson's vehicle was spotted on campus around 12:30 p.m. Here is how that played out yesterday.
Would have been just off center on the top side.
What do we see now?
This is the intersection of Campus Drive and 800 South. There's a vehicle attempting to turn right onto Campus Drive. The vehicle is driven by Mr. Robinson.
And on the screen, where is that vehicle that you're referring to located? You broke it into quadrants.
It's on the left side, on the upper side, the upper quadrant.
And then he goes forward. And the officer goes on to say that there was a contact. There's a purported alleged contact. Now, of course, it's hearsay. We did not hear from the officer who made contact with Tyler Robinson. This is coming in. It's being reported as the truth of the matter asserted, as if a police officer did, in fact, make contact with Tyler Robinson. Of course, we know, you guys should all know by now, in an actual courtroom, not a kangaroo court like what's going on in Utah right now, but in an actual courtroom, and at trial, they would not be able to introduce this evidence as evidence that Tyler Robinson made contact with a police officer at 12:30 p.m. But the reason I think it said 6:30 is if you'll notice the bottom of the screen there, it's at 6:36 Zulu time, standard time, not standard time, universal time. And if you go to Mountain Daylight Time, which is what they were on at the time, that's a 6-hour difference. So 0636 Zulu time would be 12:36 Mountain Daylight Time. I'm sure that's the source of the confusion. But the source of the confusion made its way into a Fox News article. Now I question who sourced that Fox News article, because it was someone who'd seen this footage. In my opinion, because I don't know how else you make that mistake. So why are sources in law enforcement leaking out details to the media? That's a different discussion. But that's why we said that. That's why we did that. So were we wrong? Probably. It doesn't sound like he made contact with a police officer at 6:30 p.m. It sounds like he made contact with a police officer at 6:30 a.m. Zulu time, which is 12:30 a.m. Utah time at this time of year. But you can see them, kind of get ready to turn right and then go straight. And allegedly there was a police contact that took place in there. But we know where he was headed, purportedly. If that was indeed Tyler Robinson, we know where he was purported to be headed. Why? Because we have a search warrant. And on the search warrant, it gives us a time of where he was approximately 11 minutes later. Here is what it says. Orem contacted police and advised that he had captured video on his Nest doorbell camera, a Dodge Challenger parked across the street from his home. The vehicle initially parked at approximately 12:47 hours. That should not be 12:47 hours on September 11th. That should be 00:47 hours. That was a typo, I'm sure. On September 11th, which would put it at 12:47 a.m., which would put it 11 minutes after that video we just watched, and left it approximately 01:35. So it was there roughly 38 minutes, give or take. Maybe 48 minutes. Maybe my math sucks. I heard someone, and I'll play it for you, you'll hear it too, say that 95% of the DNA, it sounds like, came from Lance Twiggs on one of the items. It was pretty shocking.
So this part right here, a lot of, I would say 90% of the objects in this case that has been collected for evidence, Lance Twiggs has his DNA on. So if your DNA is all over the screwdriver, the gun, the bullets, there's a possibility, and you guys let me know what you think, there's a possibility that Lance Twiggs may have done this. Now, we all know we're going through the motions, and I don't think neither one of them did anything. We think it happened here, right? I think it's some type of air-actuated pellet discharger that actually shot up in his throat, or, of course, the mic, and we know what the mic does. So that is our interpretation of it, unless somebody in here has a different way of seeing things. But for argument's sake, if there was another theory, because that is simply my theory and other people's theory, because the mic, is not my theory, but the air actuated pellet discharger is my theory. Okay. But it's simply a theory, and all of these are theories. So another theory is if somebody was on top of the roof. But with that being said, I think Lance did this. And here's the reason why I think he did this. He seems too excited to put his own lover to death. That in itself is not natural. Because like I said earlier, imagine you go to jail for a crime that you didn't commit, and they don't have any evidence. And then all of a sudden, your own boyfriend or girlfriend is testifying against you, and that person is literally the only evidence that they have. On top of that, though, which makes it even worse, their DNA is all over the alleged weapons that they're accusing you of using on the victim. So you go to jail for a crime you didn't commit. You have you own a firearm, or either your uncle or whoever. We're talking about you and not Tyler Robinson, right? You own a firearm, but you're in jail, and then you come to find out that your girlfriend, their DNA is all over your firearm that you never seen them handle. And you like, wait, why in the world is my girlfriend's like me? Let's just say me. Say my girlfriend's DNA is all over my weapons. I didn't do anything, but I'm in jail, but their DNA is all over my weapons. Wouldn't that tell me something instantly? That they may have taken my weapon and did something crazy and then put it on me? So that is what I'm theorizing that actually happened. I personally think if the third or fourth theory is correct, that somebody did go up on a ceiling, go up on a roof. What's up, Jersey One? And do this. It wasn't Tyler Robinson. It was Lance Twiggs. Because how are you going to happily sit on the stand and just tell on me like that? Even if I did do it, why are you snitching on me? Even though I don't think Tyler Robinson did it, but why would you snitch on me even if I did do it? Is this judge that stupid? I think this judge is really good. I think this judge is really fair. So just my opinion. So how would you feel if your own mate did this to you? 2, do you think Lance Twiggs is the one that did this? And 3, do you think this judge is fair or you don't like him? Let me know in the chat. All right, shout out to Kim Brown. Have you seen Megyn Kelly, Nancy Grace, and Fox News nauseating analysts on yesterday's trial? Unreal. I actually have not seen it. I've been looking at what Barron has been saying. So yeah. And speaking of that, let's keep going, because I have so much stuff to talk about.
There were a lot of problems with the DNA testimony, but this was perhaps overly shocking.
Is considered reliable hearsay.
And reliable hearsay is the most annoying mess in the freaking world. Every time I turn around, they're using code 1102 for reliable hearsay. Like, what are you talking about? What do you mean reliable hearsay? But reliable hearsay is not going to be reliable during the actual case. But here's what's crazy. We're not going to know anything today. They said officially that the court is going to come to an understanding, or I'm not going to say a verdict, but a decision on whether this is going to go to trial September 2026. So that means I was thinking that the second today is over, or whenever, I think today is the last day. Is today the last day? I think today may be the last day. Tyler Robinson is still going to have to be in jail, because here's the thing. Say in some type of wonderful, amazing world, the judge says there's not enough evidence to go to trial. Tyler Robinson will go home today. But because we now have to wait until September, Tyler Robinson has to stay in jail until September. So it's just like so stupid, because why can't you make your decision next week? Why do you have to wait all the way until like the anniversary of Charlie Kirk getting unalived, which is weird in itself? You're waiting until the anniversary of Charlie Kirk being unalived to make a decision on letting this boy out or either taking this to trial. And then, of course, once he makes the decision, then we got to wait another 6 months in order to go to trial. The DNA is inconclusive. Yes, it's like it's a ritual or something. Yes, this shit is crazy. It's sad, man. Shout out to Kim Brown. Do you have mother-son card deck? I have 3 grown sons. So I am working on an app, and the app is going to include every iteration of card game. Mother-son, daughter-son. I'm sorry. Mother-son, father-son, mother-daughter, father-daughter, a brother's card game, like a sibling rivalry card game. So I'm working on that app. So I have so much going on. So I should have had the app out already, but I have to do a lot of different logistics with the app to make sure the security of the app is intact, because the security of the app, in my opinion, is the most important part. The user experience and the security. I want to make sure whatever app that I come out with,
2011, I bought my first bank-owned Ford.
You know, people would be able to feel safe, and to make sure all of their information would be safe. So I want to make sure that is paramount. So yes, I am putting together an app that will have all the card games. That's why I have not came out with another physical iteration of the card games, because of that. So, all right. Thank you.
Addition, credibility determinations are not proper for the court to make here, for the whole reason that, you know, studies supporting this science, studies opposing this science, testimony from this expert or that expert about what is reliable, what is not, what's more reliable, what's less reliable, factors that affect all those determinations. Those are all very, very complex decisions. There will be probably multiple day hearings dealing with that, and a probable cause determination is just not the place to conduct that kind of thorough, in-depth, and searching analysis. Rather, the case law, the Constitution of Utah that says the only purpose of a preliminary hearing is determining probable cause, the case law, the rules that all say the court does not weigh the evidence at this stage, but leaves that for a finder of fact, the jury, in the end. That all supports cutting this line of questioning off at this point, rather than going on for into greater depth, Your Honor.
All right. So, based off of what's been presented before me, I'm going to sustain in part and deny in part the objection made. I'm going to allow this question to be asked, and so that is denying, but sustain in the sense that this would be the last question, and if Mr. Burt would chooses to, may go on to a different subject or a different line of questioning.
Sure. Did the NIST report conclude that it remains unclear if visual inspection renders consistent number of contributor estimations across analysts over time?
Can you repeat that?
Yeah. Did the report, the NIST report that you referenced, conclude?
I may have the wrong clip. Let me read. Here was the original. I think that's the wrong clip, but here is the original.
Oh, somebody asked a good question. And, make sure to ask your questions. And if you want me to see your question, make sure to put it in the super chat. Somebody asked a great question. Does Tyler Robinson have access to the internet? I don't think so, because he's still in jail. Once you go to prison, because I visited prisons, I used to go to prisons to actually help the prisoners deal with resentment and anger and all these different emotions that you deal with when you find yourself going to prison or whatever. So I've spent a nice amount of time inside of prisons and talking to, the guys in there. I went to South Carolina. So it's called SCDC in South Carolina. I was down there. So you do have access to the internet when you go to prison, but when you go to jail, I don't think you do. And of course, it depends on the state and the city you're in. But no, I don't think Tyler has access to the internet. I'm sure he can hear about what's going on, but they don't have pads or whatever. I don't think so. But they do have a TV. So if it's on the news, yes. But I don't think they have access to YouTube channels and stuff like that. So I only watched just to see what they're saying. I'm all about Baron. Yes, shout out to Baron. Yes, 1000%. Baron is the truth. Baron breaks this down in a way, because I'm using Baron stuff. So shout out to Baron. Baron breaks things down in a way where you can see it and understand it and feel it. So shout out to Baron.
Statement that I heard. She said, quote, when I compared Mr. Robinson conditioning on Mr. Twiggs, it was 5 to 95%. I heard that as Mr. Robinson to Mr. Twiggs, 5% to 95%. And so I concluded it was 95% Mr. Twiggs. She clarified that 3 hours later. Hours later, it was clarified that it was actually the opposite of that. And that's fair. I'm fine with that. And I'm fine issuing the correction. I have no problem if I misinterpret a document or a statement or testimony. But I want you to know my thinking. It was not just like, oh my gosh, we're just wrong. No, it was the part I heard, and I had a lot going on yesterday, but the part I heard, she said, Robinson to Twiggs, 5% to 95%. I had no idea she was flipping those in the middle for some reason. Now, so that clarifies a couple of issues from yesterday. I want to switch out of the testimony to something else that happened yesterday. I want to switch out of the testimony to something else that happened yesterday. Candace Owens noted that Ben Shapiro made a comment on his podcast, and it sounded like, let me pull it up. It's just 22-second clip. And this is fair use, people. This is what it sounded like.
So I remember where I was when all this was happening. I was in Los Angeles. I had sort of a breakfast/lunch meeting with somebody.
Actually, let me pause right there because I don't want to go too far. I want to stick to the actual case, but this is a conversation to have probably if we can within the next 30 minutes before the case starts, but I don't want to go somewhere else yet. But I want to show you guys this because I think this is extremely important. So I'm going to play this first and then play something else.
Yes, you guys finding the ejected rounds from police weapons today? I found at least 5. It also now, because their initial excuse, remember the investigator said, "Oh, it was a police's rifle round." Yeah. We just eject the rounds and pick them up later. Not out of AR-15 style platforms. They do not do that. If this was some bolt action sniper rifle, maybe he ejected it on the top of a white roof.
And it's an unspent round, right?
Yeah, real round. No police officer would ever do that.
Saw that I missed it. Let go. Thank you, Aaron. I'm not sure what specifically, but we appreciate you. Thank you.
Oh, thank you. I think it's relevant no matter what, because that means there was someone with an AR-15 style platform weapon on a roof in the area. At a school. Now, this is very, very interesting because this building is where we assume the potential shot may have been coming from ahead of time because 139 yards is so close. This would be about 300 yards, which you can 100% make that 300 yards as a normal shot for a good shooter. But is there line of sight? Oh, no, it looks to me like there's potential line of sight. Now we know there was someone up on the roof of that building with a rifle.
So right here, this was extremely important. So shout out to Trigger, shout out to Valhalla, and shout out to Danks, shout out to Bays, and shout out to Jesse on Fire. But this opens up a totally different conversation right here. And everybody hit the like button. Everybody hit the like button. Everybody make sure to hit the like button.
And that building is connected to the Losi Center.
So right here, the Losi Center is at the top of the screen, and they found a bullet on the white part of the building at the bottom of the screen. And as you can see, there's a walkway where, in my opinion, the person, if, we believe or, we theorize that he was, pow-powed, which I don't think it happened like that. But it seemed like that they were over here because there is an AR round, an unspent AR round, just laying on the top of this building right next to the Losi Center. So next thing you know, they're over there probably getting everything ready. They drop a bullet and then they run across this little area right here, and then they go and set up the sniper rifle. But
walk straight across. See that? Yep. So why was somebody up on that building with a rifle? That's pretty close to the building that supposedly Tyler. It's the next building over, right?
wait, let me see the side again.
Rifle. That's pretty close to the building that supposedly.
Hold
And
on,
that building
hold
is connected to the Losi Center. You can walk straight across. See that?
All right, I want to see. I'm looking at this right here. So the walk across doesn't seem like the walk across from the roof though. So if you look at it, the roof is way up here. So if the unspent round was on this roof, they would have had to go through a lot of stuff in order to get down to walk across. But why is this walkway going to the roof of the next building though? Let me see if I can get a better.
Yeah. So why was somebody up?
Right. You guys see what I'm saying? Like, what in the world? Why is this walkway headed to the roof of the next building? Can people just randomly? Because it looks like, if you look down here, it looks like there's, I don't know. It doesn't look like a roof to a roof.
Up on that building with a rifle.
I just want to look at the different angles. See, this is another angle right here. The roof is up here and the walkway is over here. But is there a door to the actual college where you can just walk out the door of the college across and end up on the damn roof? I don't really understand it. All right, so I want to look at. Okay, so now we're looking at the direct top.
39 yards is so close. This would be about.
So Valhalla's okay. See right here. I don't. It just looks strange. What is this walkway for? Because who the hell would construct a building that will have an easy walkway to the roof of a building? That doesn't make any sense.
300 yards, which you can 100% make that 300 yards as a normal shot for a good shooter. But there is their line.
Yeah, shout out to Valhalla. He is excellent, especially when it comes to this ballistic stuff.
Sight. Oh no, it looks to me like there's potential line of sight. Now we know there was someone up on the roof of that building with a rifle, and that building is connected to the Losi Center. You can walk straight across. See that?
Y'all see what I'm saying? Yes or no to chat. Do you understand what I'm saying? Like, it doesn't make sense. Just the way this building is constructed, being connected to the other building. So the only way I can understand this properly is this walkway is not a walkway. Under the walkway is where people actually walk from one side of the building to the other, right? That's common sense. But why is it a walkway that is connected to, is not connect? Okay, whatever. I don't know. I'm just a little confused.
Yep. So why would
I'm just confused on the construction of this building like that.
somebody up on that building with a rifle?
What's up, Arthur? I see you in here.
That's pretty close to the.
And thank you all for the super chats. I appreciate y'all. Kim Brown says, can you imagine Barron on the defense? Mesmerizing. Yes. Barron would get this boy off 1000%. Let's see. Shout out to Up with BM. What's going on? LT DNA, LT engraving tool, LT notepad, LT phone messages. That's all I'm saying. And LT, of course, is Lance Twiggs. That's what I'm saying. I personally think Lance Twiggs is framing this boy and nobody seems to care. And then if you just look at it like this, why does Turning Point USA or whoever is behind the framing of Tyler Robinson, why didn't they just frame Lance Twiggs? That's the thing I don't understand. Why if you need to frame somebody, frame Lance Twiggs. And this is something that I said in a Twitter space when Blake Neff was in there. I was telling people that we have to understand that when you turn around and have a body, okay? So just imagine just any city, any state, forget about Tyler Robinson. If there's a body, say somebody just passes away and there is a murder, right? The homicide unit, their goal, and I'm not going to say their only goal, but their main goal in a homicide situation is to simply find a killer of the body and get that paperwork off your desk. And a lot of people were like, so they don't care? I'm like, no. See, a homicide unit, they deal with homicides all the time. So it's just paperwork on their desk. So what I'm saying is, from a logic standpoint, all homicide units want to do is to match a killer to the body. And once they match a killer to the body, they don't want that killer of the body to be wrong. They just want to match a killer with a body to get it out of the way so they can start working on something else. Because an investigation, a state investigation, a federal investigation, is about man hours, money, resources, and time. So the faster you can match a killer to a body, that paperwork gets processed, and now everybody in that unit can work on the next homicide. And it's usually another homicide after that homicide. So no matter who dies, they're like, all right, I'm so sick of this. Oh, Tyler Robinson did it? All right, cool. Get him out of there. And then, so people, not everybody, but homicide units, people, they don't necessarily care to a certain degree who did it. They just need somebody to be attached to the body so they can move on. So I just want y'all to understand that. So for the people who think this isn't fair, which is me also, just understand how homicide units work, or how all these things work. It's just a body to them. They don't care. So they're just matching a body with, matching a killer with a body, and they're just moving on. So just keep that in mind. So it is to the best interest of the judge, of the prosecution, to put the person in jail, whether they did it or not, so everybody can go home. No matter what. The bald guy driving the car, nobody cares. The fact that it isn't even the car, because watch this, nobody cares. Watch this.
A Turning Point insider reached out to me again and sent me this message. Hey man, this was really...
Oh, hold on. This ain't it. This isn't it. Wrong video. Here it is right here.
Because he just broke a massive story.
All right, shout out to Ryan Matter. This is great information right here.
So I want to give a big shout out to Baron Coleman, because he just broke a massive story on the Tyler Robinson, the trial that's going on right now. So the judge or the defendant in the state and whatever, they're presenting their evidence. It's a preliminary hearing. So they're saying, hey, judge, here is all the evidence we have that supports our thesis that Tyler Robinson is the lone shooter on the roof. And we know because we tracked him all over the campus. And here's all the videos, and here's the evidence, and here's his vehicle, and here's him leaving and coming and going, the whole 9 yards, okay? So I just want you to take a look at this vehicle, because Baron Coleman just dropped a banger. So take a look, pay attention to this vehicle, and then we're going to show you the vehicle of Tyler Robinson. But I noticed quite a few things. After Baron pointed out this one thing, I started to really dive in and look at this. So I'm looking at this person driving, and this right here is clearly a hand and clearly a...
And the hearing has not started yet. Just so y'all know, the hearing has not started yet.
Face. That is undeniable. That's a hand and face. Well, that's...
And I'm just gonna tell you, I don't see a hand or a face, so I don't agree with Ryan right here because I don't see nothing. But I can't see that well. So, do y'all see a hand in the face? Yeah, everybody in the chat, everybody in the chat say free Tyler Robinson. Everybody in the chat say free TR. So I'm gonna play this again. Maybe I can't see well. Let me know if y'all see a hand in the face in this picture.
Mr. Barron pointed out this one thing I started to really dive
I'm gonna make it bigger.
in to look at this. So I'm looking at this person driving, and this right here is clearly a hand and clearly a face. That
Do y'all see a hand in the face? I'm looking at it. Everybody in the chat say free TR. I see a hand in the face. No, it's not a hand in the face. We're trying to make it into a hand in the face, but I don't see nothing. I don't see, do y'all see a hand in the face, or can I just not see? I can't see. So I don't know what he's talking about. A hand in the face. You can assume that's a hand in the face, but it's just a fuzzy image.
is undeniable. That's a hand in the face. Well, that's the arm right there. What is that person wearing? Well,
Okay, so right there. I just see fuzzy images. You can assume that's a hand in the face. Of course, that's a hand in the face because they're driving. So you're assuming that's a hand in the face or an arm and all the other stuff. And they got black on. But that does not mean it is Tyler Robinson or it isn't Tyler Robinson, because this is the actual problem with this whole case. Virtually every image looks like this. And then now people are turning around and saying, we got him. That's Tyler Robinson. Or that's not Tyler Robinson. So this is the actual problem, y'all.
person's wearing a long black sleeve shirt.
Okay.
You know, like the outfit that they claim that Tyler Robinson changed into. When I'm looking at that vehicle and, you know, you're like, yeah, that's a really bad picture. I'm like, have you seen the pictures that they tried to convince us that were Tyler Robinson?
Exactly.
Now the next thing I want you to take a look at, this is the one that Barron pointed out. Now, let me show you. This is Tyler Robinson's car. What do you notice? You notice this license plate holder?
Now
Let's go back. You guys notice? You guys see any license plate holder on there? Now,
yeah, now you see what I'm saying. They're like, he's like, there's a hand in the face and they have black on it. That doesn't mean anything. And this is the problem with this damn prosecution trying to just show images like that saying that's Tyler Robinson. No, it's a person driving a car and they have on a black shirt. That doesn't mean anything. But what he's saying about the front of the car, I can agree with. But the hand in the face mess, no, that's dumb. But let's look at the front of the car. And we're not, the trial has not started yet, just so y'all know.
The pictures that they tried to convince us that were Tyler Robinson. Now the next thing I want you to take a look at, this is the one that Barron pointed out. Now let me show you. This is Tyler Robinson's car. What do you notice? You notice this license plate holder? Let's go back.
The whole case is hearsay.
You guys notice? You guys see any license plate holder on there? Now, the next thing that Barron didn't point out, or I don't know if he did because I didn't sit there and listen to the whole video. I just got so excited when I started seeing these things. Look at this grill. You know, this one has this lip on it. It's almost like it's one of those custom body kits that they added that lowers the front of the vehicle. Now let's go back to Tyler Robinson's car. There's no lip. Like that car goes in on an inward angle.
Do y'all see that? Another example of how this was not done by Tyler Robinson, and Tyler Robinson is innocent.
This car comes out on an outward angle. I mean, that's obviously, like, there's obviously some type of body kit on this vehicle. And then you look at the vehicle. This was the photos right before the vehicle was towed from Tyler Robinson's driveway. And then when you look at...
It's not Tyler Robinson driving. It's not Tyler Robinson's car. And that second person in the black isn't even Tyler Robinson.
At them side by side. That is not that. That is... Yeah, I would say it's maybe in the light over here, okay, in the sunlight, it looks like it's not as dark blue as this. But this doesn't even look remotely close to this vehicle, not in my personal opinion. Now, I'd love to get a shot of the rims because we can clearly see the rims on there. I should go back and see if there's any photos of Tyler Robinson's vehicle in his driveway that show the rims. I think that's a different car.
It's a different car. I'm just showing y'all more proof that Tyler Robinson didn't do this. And this shit is just getting crazy. It's just absolutely getting crazy. All right, so I'm checking on the, okay, so they have not started yet, just so you know. They have not started yet. All right, and this is, let's see. Let's do this. Let's see. Let's do a brief synopsis on what went on yesterday. All right, so this is from Barron's show. Because shout out to Barron. I'm only listening to Barron, just so y'all know.
Framing an overall thesis.
Come on, thing. Oh, I know what I'm doing it wrong. What? Oh, forget it. I'll just read it. All right. The episode opens with the host, Baron Coleman, declaring that the state rested its case in a preliminary hearing and that the defense is now begun actively pushing back. He frames the entire show around a promised versus delivered structure. The he is Baron Coleman. For months, he says the public has told prosecutors that a mountain of evidence against Tyler Robinson, and there, of course. Oh, we're starting. Hold on, let's see. Okay, we're not starting. The music just came on. Okay, so in the background, I have the. Let's see. All right, so nothing is happening yet. So I'm watching though, but nothing has happened yet, and just letting you guys know. All right, so let's keep going. An open and shut case because of this mountain of evidence. But as you see, there is no mountain of evidence, and all of this stuff is literally legal hearsay. His stated goal for this episode is to walk through each piece. Yeah. All right, the roommate identification testimony. A large chunk of the show centers on the testimony of Robinson's roommate, which is, of course, Lance Twiggs. Prosecutors show Twiggs a set of campus photos of the shooting suspect and asks if he recognizes the person. Barron plays and replays the moment where Twiggs says, "I wouldn't say it's 100% certainty." And that is the thing that I'm sitting here with my mouth or my jaw on the floor like, this is your whole boyfriend and you don't recognize your own boyfriend. That is more proof that he did not do this, because you're looking at your own boyfriend and you don't even recognize the person on the screen. There's no way in hell if I have a woman and we live together and we've been together for some years and I see her on camera somewhere and I know how she walks and how she moves and her body language, and I'm going to turn around and say, I wouldn't say it with 100% certainty, because no, I would know her from anywhere. So that shows you that the person in the black in that video is not Tyler Robinson. All right. Noting only that the clothing, jeans and a hat, says he never seen Tyler Robinson wear before. And Tyler Robinson doesn't even dress like that. So that's just more proof. All right. It looked generally familiar. Barron treats this at length as reasonable doubt. He argues that if the person who lived with and reported an intimate relationship with Tyler Robinson, how in the world can you not recognize the damn person that is in the video? A jury shouldn't be expected either. He also raises concerns about the format of the testimony himself, delivered remotely with other unseen people in the room. That means since this situation with Lance Twiggs was delivered remotely, which is weird as hell, there was no cross-examination. I didn't see a cross-examination of Lance Twiggs. Was there a cross-examination yesterday that I did not see? Let me know in the chat. Because I didn't see a cross-examination. So I don't think they're going to get an opportunity to cross-examine Lance Twiggs. But let me know if I'm wrong. I may have missed something. And let me see if they are ready. All right. The show has not started yet. Well, the trial has not started yet, just for the record. All right. So let's see. Okay. Barron walks through the DNA evidence point by point on the trigger, the towel, the screwdriver, and the rifle stock. In each case, he emphasizes that multiple other people's DNA are also present at each location, not on just each part, each location. Arguing this undercuts the DNA, the idea that the DNA evidence is uniquely incriminating. Exactly. He also flags that he considers procedural irregularities. The police officer's body camera reportedly failing right before the screwdriver and it was discovered on the roof. Think about that. More evidence that all of this is some bull crap. His body camera stops right when he gets on the roof. I forgot about that part. And an unidentified plainclothes individual who accompanied the officer, which is absolutely nuts, but was never identified by name or agency. So the text message timeline. Hold on, let me check, make sure. All right, they haven't started yet, just so y'all know. They have not started yet. The text message timeline. This is the most detailed part of the episode. Barron walks through a series of text exchanges reportedly between Robinson and Twiggs, making several distinct arguments. First, he notes Twiggs testified under oath that he heard nothing from Robinson until an automated 11 p.m. text. But the actual message, the message itself, records appear to show at 4:33 p.m. So 11 p.m., but the actual text message appears to show 4:33. All right. That exchange with Twiggs didn't mention Barron. And that's the reason why I'm looking at what Barron said and not what the court said, because Barron is a lawyer and he's going to let you know exactly what's going on versus all the other shit. So Barron calculates that 43 p.m., which would be roughly the drive time from Provo area back to St. George, and floats the possibility that the timing suggests that Twiggs himself could have been near the scene that day rather than at home. Do y'all see that? Do y'all see that? And that is my point. So I want to say that again, and because that is very freaking important right there. Twiggs testified under oath, I'm repeating this, that he heard nothing from Robinson until 11 p.m. It was an 11 p.m. text, but the actual message records appear at 4:33 p.m. An exchange with Twiggs he did not mention that part. I'm saying this again. Barron calculates that 43 p.m. would be roughly the drive time from Provo area to St. George, and floats the possibility that the timing suggests Twiggs himself could have been near the scene that day instead of being at home. Second, He cross-references testimony placing Tyler at the steakhouse in a town called Panguitch, around 9:30 p.m. He argues that is geographically incapable with text describing him hiding near the crime scene and worrying about. Oh, okay. He's talking about when he was hiding in the bushes and he seen a police car lingering around in the text messages. I remember that. Okay. And the text describing him near the crime scene and worried about a lingering patrol car around the same time. The drive between the two locations, he says, takes several hours. This is more evidence. Man, I wish Barron was on this damn case. He would have blew this case out of the freaking water. Let me check. All right, so let me see. Nothing is happening yet. Just so y'all know, nothing is happening yet. Actually, I'm just going to leave the audio on, and whenever it comes on, I'll actually hear it in the background. Okay. Third, he rises writing style objections, comma placement, and considers inconsistent with. Hold on. Why not have Tyler Robinson write on a piece of paper? Why didn't they have Tyler Robinson write something on a piece of paper? Did they do that? I don't think they did that. Okay. Third, he raises that writing style objections, comma placement, and considers inconsistent with someone who scored a near perfect ACT, which is another thing. Why in the world would he go unalive somebody and you're this brilliant? Tyler Robinson was really smart. And his most repeated point, a Commonwealth British style spelling of the word caliber, which he argues is no American 22-year-old would naturally use. He connects this, he connects this to an offhand comment about the lead investigators having what he describes a Commonwealth accent, implying of a possible connection. This is great. Because here's the thing. With a handwritten note, why don't they just have Tyler Robinson write a handwritten note and put his handwriting next to the handwritten notes and see if it's him? Barron spends time on a note supposedly left. Remember, Tyler Robinson allegedly told Twiggs, look up under the keyboard, and it was a handwritten note. So Barron spends time on a note supposedly left for Twiggs, questioning its chain of custody. I think somebody said that it was burnt or something. It burnt up or some shit, which is some bullshit. Okay. He points to the metadata in a photo of the note. It's a photo of the note, y'all. A photo of the note, which is absolutely stupid, suggesting that it is photographed several days after the event, which conflicts with the earlier account that the note had been burned. This whole situation is absolutely stupid. Hold on, let me check. All right, so there's nothing happening yet. So we're still waiting. We are still waiting. All right. He also questions at the practical logic of taking a photo of a note if the intent is to destroy it. And again, emphasizes that no one clarified during the testimony who actually burnt it. Why in the hell would you set evidence on fire? It is so many parts of this shit that is absolutely dumb. All right. This mess would give you a freaking headache. All right, let me stop sharing. I'll go to that later, but I want to focus on this and see what's about to happen next. All right, so I'm going to share my screen and we're going to go into the courtroom. And thank you guys for being here. All right, so as you can see, nothing is happening yet. All right, let me read the super chats. And thank you guys for being here and thank you for your support. Why is my screen so small? Okay, in my opinion, Lance Twiggs told on Tyler Robinson before Tyler Robinson turned himself in. They lied saying he turned himself in first, then found all the footage, many unlikely patsies on campus. Everybody on that campus looks like Tyler Robinson. They are shaped like Tyler Robinson. They are somewhat the same height as Tyler Robinson. But that's not something that's crazy because at the end of the day, a kid looks like a kid. You ever seen kids just running around? They all kind of like look the same, right? So teenagers look the same when they're walking around on campus when they got their book bags on. I'm sure we've all drove through a campus or something, and you'll easily see that all the kids somewhat look the same. All the girls look the same. Kids, you know, before they're adults, they all look the same. So it just is what it is. Hold on. When I share the screen, my whole everything. All right. So we're still waiting. I just can't share my screen yet because I started losing access to the damn chat. All right, so let's go back to. I want to play this real quick.
Any footage of the alleged shooting?
There is not, Judge.
Okay.
So, as y'all can see, this was from, I think, day 3. And I think this is one of the most important parts of this whole case. So listen to this again.
Is there any footage of the alleged shooting?
There is not, Judge.
Okay, I just wanted to clarify that. Ms. Nestor, given that additional information and anything further from defense?
No, but I think I'd like to be crystal clear. You asked if there's any portion of this video that captures, and I believe you asked of the actual shooting. There's no video of that. There is video, however, and you've heard testimony related to this, where the shooter goes to the top of the low-C building, goes out to the edge of the building, low crawls, and then leaves after what we assume is the shot being fired. That's as close as it gets.
And
make sure to hit the like button. Make sure to hit the like button. Make sure to hit the like button.
the court also recognizes Utah Rule of Evidence 1102 as that is the foundation that's being laid for the admission of this exhibit.
And of course, it has not started yet. I'm keeping an eye on it.
Taken in consideration all factors, the court rules that Exhibit 12.4 is admitted into evidence and shall be played in the courtroom and may be broadcast by the media.
Building.
Correct.
Wasn't there also a bullet found on another building?
I believe an unfired bullet had been found on another building at some point during my time there on September 10th. Yes.
Which?
And listen to how, hold on, let me mute this. And listen to how the guy literally says, I don't know what type of bullet was found on top of the building. Come to find out, it was a .223 round. Listen again.
I believe an unfired bullet had been found on another building at some point during my time there on September 10th. Yes.
Which building was that, sir?
I don't recall.
Was that considered a scene that was worth preserving?
It was not. My recollection is that was accounted for as an ejected cartridge from an officer who had cycled his rifle.
Officers do not have AR rifles, just for the record. So he's lying right here. Police officers do not randomly, especially on especially an officer on a college campus is not going to have an AR style rifle.
Okay, I thought you said it was an unfired bullet, and now you're saying it was a
that's correct.
cartridge?
When a weapon is cleared, an officer would make his rifle ready, which would chamber around.
Oh, I got you.
My understanding was that that's how that was accounted for.
So an officer
Thank you for the Flow State 200 joules. Thank you, Caroline.
claimed that bullet belonged to him or her?
That's my recollection, is that was how it was accounted for.
And when was that accounted for?
I don't know specifically.
Do you remember what type of bullet that was?
I don't.
Was it a 30-06? Do you remember?
I don't.
See, he doesn't even know what type of bullet. How? Like, who are you? You're lying, sir. You're an investigator. The head of the investigation team. You look down and you see an unspent round on the ground, not on the ground, I'm sorry, on a roof, and you don't know what type of bullet it is. And again, this is the roof right here.
No matter what, because that means there was someone with an AR-15 style platform weapon on a roof in the area. At a school. Now this is very, very interesting because this building is where we assume the potential shot may have been coming from ahead of time because 139 yards is so close. This would be about 300 yards, which you can 100% make that 300 yards as a normal shot for a good shot.
So this is where the round was found. 300 yards away from Charlie Kirk. And according to Valhalla, shout out to the guys, they could have shot from this angle to a certain degree.
Shooter, but is there line of sight? Oh no, it looks to me like there's potential line of
See, it's a line of sight.
Now we know there was someone up on the roof of that building with a rifle, and that building is connected to the Losi Center. You can.
So as you can see, it's a line of sight. That's a long ass way. So as you can see, that is where Charlie Kirk was right there. So there is a line of sight. You see that? That's a long ass way, but it's a line of sight.
And that building is connected to the Losi Center. You can walk straight across. See that?
And because remember I was talking earlier, I just saw my own case. Remember earlier I was saying that this building is elevated? Because that building is elevated, that's the science building, that gives that person a line of sight from that building over to where Charlie Kirk was. So right here, that's the courtyard where Charlie Kirk was. So watch this.
And that building is
okay. So this building
connected to the Losi Center. You can
right here is elevated, and you're going to see that is elevated in a second.
Walk straight across. See that?
So forget about walking straight across. They could have set up right here and they would have had a pretty good line of sight because this area is so elevated. I answered my own question from earlier. See right there? It's elevated. So they could have been on this roof and shot down. And just to add, I don't know, some type of logic to this. Let me know what you guys think. Because the science building is like this, that would mean, okay, so think about this. Charlie Kirk is down here, right? Everybody is looking at the Losi Center and they're shooting from here, right? And they're like, they shot the gun and next thing you know, it hit his neck and then the bullet did not fracture anything because that makes no sense, right? But the Losi Center is here and Charlie Kirk is here. But the science building is up here. So the science building is up here. So somebody shot a 30-06 round from 320 yards, I think Valhalla said, from an elevated roof or a higher elevated roof and shot from there and hit Charlie Kirk. I want you to think about this. Yes, I know the microphone. I'm just looking at the theory. I'm considering this theory, okay? I'm just considering this theory, all right? Guess what? And this might be like breaking news or something. If that person from 300 yards is starting, okay, put a pin in that because I think I got something. Hold on, y'all.
Please state your roles for today's hearing.
My role is to capture pool photography, still photos.
Put a 1 in the chat if you can hear me. I mean, hear this. Put a 1 in the chat if you can hear this. Put a 1 in the chat if you can hear my screen.
My role is for video in accordance with the court-to-court order.
And I apologize. Would you mind putting your names on the record?
Tess Crowley, Megan Thackeray with KSL.
Thank you. Have you both reviewed the court standing decorum order?
Yes. Yes.
Do you understand the requirements set forth in that order as it applies to your
Put a 1 in the chat if you can hear me. I don't want to just be playing and y'all can't hear it. Put a 1 in the chat if you can hear him, I meant.
activities today?
Yes.
Do you require additional time to review the order or to adjust equipment to ensure compliance?
No. No.
Do you anticipate any difficulty complying with the order?
No. No.
All right. Thank you both. Before we begin this morning, the court wishes to acknowledge the importance of the safety, dignity, and well-being of all those who are present or who may be present during these proceedings, including the parties, counsel, witnesses, court staff, and members of the public. The court is also mindful of its solemn obligation to protect and uphold the constitutional rights of Mr. Robinson and Ms. Kirk. In furtherance of those important interests, all persons attending these proceedings are reminded that portable electronic devices are not permitted in the courtroom or on the fourth floor. Cell phones are not permitted in the courtroom unless expressly authorized. Any unauthorized possession or use of a cell phone or electronic device in the courtroom may be addressed by the court. For those individuals who have a cell phone, I invite you to join me as I silence my cell phone to ensure that the proceedings today can proceed without distraction. The court also expects every person in attendance will be treated with the dignity and respect to which they are entitled. Consistent with this court's standing decorum order, all spectators shall remain quiet, civil, and orderly at all times. Spectators shall not engage in conduct that is distracting, disruptive, provocative, disrespectful, uncivil, or threatening in any manner. Spectators shall not make audible comments of any kind, shall not shake or nod their heads, and shall not make gestures or of other visible reactions during the hearing. Spectators shall also not wear or display pins, buttons, signs, clothing, photographs, or other items expressing support for or in opposition to any person connected with this case or expressing any position concerning the status of this case as a capital offense. The court appreciates the cooperation of all present in maintaining a courtroom environment that is safe, respectful, and orderly, and faithful to the rights and dignity of every person involved. All right. My understanding is the parties wish to address an issue before we get started. Is that correct?
We may.
Mr. Novak.
Thank you, Your Honor, and good morning. I passed up to the court after providing copies of it to counsel for the state and counsel for the media, a single piece of paper. Does the court have that?
I do. Thank you, Mr. Novak.
Thank you, Your Honor. So every morning, this court has a colloquy with the camera operators about their ability to comply with this court's orders. And they acknowledge that they understand the order and that they can comply with it. And the court asks them if they have any problem with it. And they state to the court that they do not have a problem with it. We also spent many, many, many hours of court time addressing which exhibits will and will not be published through the electronic media. And this exhibit the court ordered would not be published through the electronic media, and it was. And without belaboring the point, the court can imagine our concern that the media and the state who control this exhibit and the publication of this exhibit in the courtroom, as per the court's orders, failed to comply with this court's orders after all of the effort that we made and the court made to make sure that the court balanced everybody's rights, including the rights that we're concerned about, which are Mr. Robinson's.
Uh-oh.
No doubt the counsel for the media and counsel for the state will say that it was a very, very brief mistake, that it was corrected as soon as they realized the error, but it's done. It's out there. It's photographed. I'm informed secondhand that if I want to buy this image and maybe even have it framed and put behind museum quality glass, I can do so and put it up in my office. Obviously, I'm not going to do that. But my point is, it doesn't matter how long the court's order was violated. When we live in an electronic world, it's done and it's permanent. And we just wanted the record to be clear that we're concerned that the court's orders have been violated, and they've been violated with respect to an order that was specifically designed to protect Mr. Robinson's right to a fair trial. And I don't want to belabor the point any further. I'm also not going to refer to the exhibit with any more specificity because it's not necessary.
He's pissed.
Is there a requested remedy or potential sanction that you feel is warranted given the actions which you have outlined this morning?
I think that we would like to think, when I say we, I mean Mr. Robinson's counsel, about that. We have, as the court knows, repeatedly asked this court, moved this court, not to have electronic broadcast of this proceeding, of any of the proceedings, and specifically this proceeding. The court denied those motions and overruled our objections to the specific EMC requests. So I think it's a little premature, but I can represent to the court that we will suggest a remedy in advance of the next hearing.
Well, Mr. Novak, I appreciate that, but I would ask that if it is something that is concerning, that it be addressed immediately. So I'm not going to wait until this. I recognize and appreciate what you have described, and this was on my mind a lot last night as well.
Okay.
I don't want to sit on this. So I ask you respectfully to confer with your counsel and come up with that, because I want to address it. I agree. It is concerning and it warrants examination and to be addressed immediately, especially as we have a little bit left of our preliminary hearing. So I want to give it the weight it is needed, and I don't disagree with you.
Then why don't we beg the court's indulgence? We don't need to empty the courtroom. We can go talk about what we think an appropriate measured sanction would be. And we can bring that suggestion back to the court in a few minutes.
All right. Well, before we do that, I want to turn to the state and to the media to address what you've addressed. And then obviously if there's a part two, then therefore.
And I appreciate the invitation. And I also appreciate the court's desire to address the consequences, if any, immediately.
Thank you, Mr.
I was not trying to delay it. I just think
he is pissed.
It's an issue which warrants some thought. The court has said it gave it some thought. We will have a suggestion very briefly.
Thank
you. I wonder what happened.
To the state.
Thank you, Your Honor. I think at the outset, it's important to recognize that everyone's doing their best here. The court is, I know the clerks are, I think the media is, we certainly are, and the defense is. This issue came up in the context of an examination of a witness. One exhibit was published before the exhibit at issue was also brought onto the screen. I explained what we were going to do, and then the exhibit was brought onto the screen. I reviewed the video last night. The camera captured this for approximately 2 seconds. The camera operator, I think, acting in diligence and appropriateness, immediately panned as soon as she realized that there was a new exhibit on the screen. The court took it down. As soon as they realized that an exhibit was on the screen, I immediately instructed my paralegal to take it down, and it was. Defense, I think everyone involved here made quick and appropriate efforts as soon as they realized a mistake had been made to remedy and mitigate that issue. As I explained what I was what we were going to do, defense counsel did not object as that happened. And the reason I bring that up is because of the requirement for timely objections. Moreover, I do want to say this exhibit was read into the record. It was allowed to be read into the record earlier. It is also in an earlier pleading, which is the information. This portion of that exhibit, I understand, is in the information. And it is largely cumulative of Exhibit 16 and 16.1, which were previously admitted into evidence and published to the media. Finally, we are going to be dealing with a lot of publicity when it comes to media coverage. And I think that's really where the remedy is going to be addressed. I understand there may be a remedy that can be fashioned today to prevent this kind of thing going forward or going on in the future in this hearing. But I think ultimately that's where this will be addressed. Any other questions from me, Your Honor?
Well, not at this time. I will afford you the opportunity, obviously, to respond when defense comes back. I want to weigh this and taking in consideration, and I find your representations to be accurate as to what occurred. I believe that I noticed it and asked for it to be taken down because I have a live stream on my screen for that very purpose. And the sequence, I believe I made note, and if I'm wrong, please correct me. It's been a long 4 past days, but that's the only addition that I find to the representation. And certainly, Mr. Novak, feel free to correct it if you believe the sequence was any different. I just want to make sure a clear record is being made of what happened in order for whatever happens next to be appropriate and proportional to the actions that occurred.
No, and that's consistent with my memory. And I also reviewed the video, the live stream as well in preparation for this issue today. So that's exactly what I think happened. From my perspective, examining the witness, I did not have a view of what was being published to the public and the media. And so I think the court immediately, as soon as it recognized that, brought that to everyone's attention.
Thank you, Mr. McBride. To the media.
Good morning, Your Honor.
Good morning.
Appreciate the opportunity to be here to speak on behalf of the media. I think our understanding of what happened is consistent with what both the defense and the state have said here. So I don't want to belabor that point. But here's how I understand it. There's 2 exhibits at issue. Those exhibits were used yesterday in part because the juxtaposition of those 2 exhibits might have provided some sort of benefit to the court. The first of those exhibits was asked to be published through all 3 of the court's phases. The court said it will be admitted into evidence, be shown in the courtroom, will not be shown on the cameras. That happened about 3 hours into the hearing. That all went smoothly and well. That operated exactly as it is intended to. That requires the participation of everyone, the court, the defense, the state, media, camera operator, all to do that well. Later in the day, when in the video I reviewed, this was about 5 hours into the runtime yesterday. The second exhibit that was going to be compared side by side was introduced. That also went through that 3-step process. In that case, the court said that could be admitted into evidence, shown to the court, and then also shown on the cameras. So it was put on the courtroom cameras. At that point, there was what I think is a useful practice by the camera operator to wait a beat, because sometimes mistakes do happen, right? In that case, though, that was authorized. So the camera then panned to the screen, which is set up specifically for the camera operator to be able to capture that. Examination on that exhibit began. Then, because the examination seemed to call for that juxtaposition, without much warning for anyone involved, the previous exhibit that was intended to be juxtaposed was placed on the screen. From, I think, a observer's view who didn't know where the testimony was going without warning. The camera operator, I think quite astutely, within seconds, recognized this is a different exhibit. And recalling the court's prior order, recognized I should pan off, and did within seconds. I think at the time that was happening, the court also caught that and said, let's not do that. Now, and that was the end of it. I think the 2 seconds is about right. I don't want to minimize that. I understand the point that Mr. Novak is making. We are operating in some ways on high wire. And we are trying to place as many nets as we can. And all the parties are working together to try to do that. But in the age in which we live, one of the challenges is that sometimes when something like that is placed on a live stream, someone can screenshot it. And like Mr. Novak said, if they want to put that for sale on the internet, then they can. That's why working together to ensure that even small mistakes like that don't happen is critical. And the media has the media coalition that are given the opportunity and the benefit of being able to be here to run cameras and to take photographs have complete buy-in on that point. There are, of course, people out there watching a live stream that are not part of our coalition that we can't control. And that's why it's so important that we get these pieces right. I do want, without going too far into the evidence, to note not only that several lines of this exhibit are available publicly in the information, but that the full text, every word of that exhibit is contained in a search warrant, in this case, that was initially filed on September 17th. This is in the 4th District, but in a different court. Was held for 6 months, as search warrants often are. But then on March 17th, March 16th, March 17th, was released in full. On page 7 of that search warrant is the full text of this exhibit. I don't want to suggest that anybody gets the right to say, well, I think it's public. The court has said don't show it in the screen. But since I think it is, we'll just come back later on and tell the court it's not a big deal because it's already public. That's not how it works. If we say we think it's in the public, the court says, I understand that, but I'm going to make an order. That order should be adhered to. But I do, for the purposes of prejudice, for potential remedy, for the court's concern and the court's sleepless nights, I do want the court to know that as well. And members of our coalition have pointed out to me as we've talked about this, while we take this very seriously, it is true in this case that the full text of that, not the image of the exhibit itself, but the full text is already in the public sphere, has been reported on, and is out there. I only want to reinforce, to close, the recognition that the media, our coalition, I, as an attorney for that coalition, have an obligation to make sure that mistakes don't get made. And in this case, even though I believe that the camera operator didn't act in violation of the court's decorum order, didn't do something that was forbidden by that there was an order that said, don't publish this exhibit. And because it flashed on the screen when the camera operator was filming that screen, that did happen. The media is fully bought in. I, as one of the attorneys and the other attorneys for the media coalition, are fully bought in on a goal to make sure that this kind of thing doesn't happen. Of course, I understand Mr. Novak and the defense's need to make a record and make an objection. And I also recognize and appreciate and understand the court's role in trying to make sure it imposes whatever sort of direction, caution, sanction, response that it believes is needed to make sure that its orders are recognized and adhered to. And I want the court to know that we will understand that and will comply with whatever it is that the court orders.
Thank you. Anything further before we break? Mr. Novak?
We don't need a break.
Okay. Well,
The court wants a break.
I want to review this. I'm sure there is a stream out there. I want to look at it again in order to appreciate the full effect and exposure. I remember it, but given the nature of this and trying to weigh the constitutional rights of all parties, I want to be thorough and look at it exactly. So as we move forward, as I evaluate what's being requested by the parties, that I am at the level of knowledge and because for what it is, it was on screen. I want to look at it, how long, what exactly was on screen, and in order to be at the point of saying, okay, I fully understand. I mean, I was here, I saw it, I noticed it on the screen, but again, I want to take that extra 2 minutes to review that.
I am not suggesting that we rush through this at all. I just wanted the court to understand that our request for the remedy and the sanction, we are prepared to share that with the court, but we can certainly wait until the court has had an opportunity to review whatever the court thinks it needs to review. The permanence of this violation of the court order is a different issue from how long it took to correct the violation. It's a permanent consequence. In other words, that image is out there forever and ever in violation of the court's order, no matter what actions the court, the state, and the media took to remedy it, because that's the technological world we live in. So that's my response, if I may, to the arguments. But we can hold our suggestion until the court's ready for it.
All right. If the parties feel it'd be helpful to confer while the court is reviewing it, you may, just so that if you choose to, I encourage it. If you don't, I respect that. A court's going to take about 5 minutes. Again, I just want to review it, to be brought up to full speed and just to have it freshly in my mind.
I'm going to make one more point, if I may, and that is, this is not the first time that this has happened. We had earlier proceedings in this case where the cameras depicted images inside the courtroom that the court had prohibited, and the court imposed certain consequences on the media as a result of that. And so that's just something to keep in mind, in my opinion, if I may. Thank you.
All right, before the court takes a 5-minute recess and to review this, does any party need the benefit of the record based off the dialogue between me and Mr. Novak? All right, not seeing any party respond. The court's in recess. We'll come back at 9:45. Court is in a brief recess.
All right, court is in brief recess. So, ask your questions in the chat, and depending on what the question is, I may be able to ask Baron and see what he thinks. I'm not saying I'm always going to ask Baron something, but if your question is extremely important, I might ask Baron, hey, what do you think about this? So ask your questions via super chat. And if the question is worthy of Baron's time, I may ask Baron, but I'm not going to be bugging Baron because Baron is probably watching the case himself. But, just let me know. So while we wait, we got a 5-minute wait. I want to share what I was saying earlier, because this may actually be something that may come up in this case. All right.
Yep. So why was somebody up on that building with a rifle? That's pretty close to the building that supposedly Tyler. It's the next building over, right? It's not like this building is somewhere else.
All right, hold on a second.
Yeah, this is where Tyler was right here.
You just walk straight across. You walk straight across that building.
All right. So the only thing I was thinking about when we was doing this live was the walk straight across the building to get to the top of the building. But I'm just going back to what I was saying earlier. I'm looking at line of sight and how the 30-06 did not just blow up Charlie's neck, if that was actually what happened. So let's look at this in a different way, because we didn't really think, we just touched on this and then moved on. So let's start over. So check this out.
Assume the potential shot may have been coming from ahead of time because 139 yards is so close. This would be about 300 yards.
So this is 300 yards away, right? And it's extremely elevated compared to the Losi Center.
Which you can 100% make that 300 yards as a normal.
All right, so right here. And so at the top of the screen, all the way at the top of the screen, that is where Charlie Kirk was, okay? So the science building, if he was at the top of this science building right here, the science building looks like it's probably maybe 30 feet, or I would say 20 feet higher than the Losi Center. So because of the elevation and the longer trajectory, because it's 300 yards versus 100 yards, somebody can efficiently aim a 30-06 weapon from 300 yards, and by the time they hit their target, the 30-06 would lose a lot of its momentum and die off in Charlie's neck. So let's look at this right here.
Shot for a good shooter, but is there line of sight? Oh, no.
There's a line of sight.
Oh, it looks to me like there's potential line of sight.
So if you look at his cursor, if you look at the top, that's where Charlie was. All right. Put a 1 in the chat if you're able to see where Charlie was in this picture. Put a 1 in the chat if you're able to see where Charlie actually was. Can you see the courtyard is right at the top? So if you look at the top, look at the shapes at the top, Charlie was under the ruler. You see all these shapes, right? Charlie was at the ruler. So put a 1 in the chat if you're able to see where Charlie was in this picture right here, okay? Listen, I understand microphone. Yes, microphone. Yes. You got to understand, right now, I'm thinking in the context of how the court is thinking, okay? So let's theorize this, because all of these are theories. So we don't know. So put a 1 in the chat if you're able to see where Charlie was in this picture. Because if not, I'll change the angle a little bit. Okay. So what I'm trying to show you is that if somebody did shoot a 30-06 caliber rifle from 300 yards instead of 100 yards, that bullet would have died in Charlie's neck and not went through his neck. That is all I'm saying. Okay. Okay. So let's look.
Now we know there was someone up on the roof of that building.
So right here. So this is where Charlie was in the courtyard, right? You see the little triangle shape. Okay.
With a rifle. And that building is connected to the Losi Center. You can walk straight across.
See, we're talking about him walking across to the Losi Center. What if he didn't walk across to the Losi Center and he just stayed on the top of the science building? It all would actually make sense now if that actually happened. And everybody watching, make sure to hit the like button. Some of y'all have not hit the like button. Hit the like button so YouTube would send this out to other people. So hitting the like button will send this video out to other people. My channel is shadow banned for whatever reason, I don't know, but trying to get it back in the algorithm. All right, so please hit the like button. So I'm just saying.
Yeah. Yep. So why was somebody up on that building with a rifle? That's pretty close to the building that supposedly Tyler. It's the next building over, right? It's not like this building is somewhere else on campus.
Yeah, this is where Tyler was right here. Yeah.
So where Charlie, forget about Tyler, just look at where Charlie was. I think this is a possibility.
You just walk straight across. You walk straight across that building to that building. Somebody was on that building with a rifle, an AR-15 style rifle. Yeah.
We didn't even think about whether it could have, we didn't break down that thought process. We just talked about the walkway.
Walk over to the other building. Maybe somebody started off over there to get everything ready, and then they walked over and got ready here.
And this is where he jumped off, supposedly, over here.
Mm-hmm. Yeah. I mean, it's very close. Yeah. One building over. That makes it a lot weirder. The fact that it's the building right next to it that has a platform that connects the two roofs. Look at that. That walkway connects those two roofs. Right. You can walk straight across there. Go and, do crime scene analysis on and found a rifle round up there. That's crazy. Pretty weird. Tell me what you think about Chris.
So, just a question, because I know what y'all about to say. It was the microphone. It wasn't a 30-06. I get it. And I agree with you. Remember, my theory was what was my theory? The air actuated pellet discharger. Okay. So yes, I have a theory of myself or for myself. So the question is, Could this third or fourth theory actually happen? So the theory is Charlie Kirk is right here. The Losi Center is right here. But the science building is up here. So here are the variables. If somebody shot a 30-06 weapon from 300 yards all the way from there and hit Charlie Kirk, and it's just a theory, just work with me, okay? From here to all the way here, once it would have gotten to Charlie's neck, the momentum of the bullet would have already died, which means the bullet, for two different reasons, could have stayed in Charlie's neck. The first reason, of course, the momentum would have died. But the second reason is because it was at an elevated level. Because people are saying it would have went straight through, right? But if it was at an elevated level like this, the bullet would have came from up above and would have went down and not through. So put a 1 in the chat if you understand what I'm saying, because I want to explain this properly. So we're thinking the bullet came like this. If there was a bullet, is a possibility the bullet came like this way instead of this way. So if it came this way, yes, it would have went through just this fleshy part of his neck. But what if it came this way? It would have went down. And that's where they're saying the bullet went. So 300 yards, the momentum of the bullet would have slowed down. So it could have, that's one thing. And then mixed with the fact or the assumption that the angle of the bullet would have went this way instead of this way, it would have went down into his body and lost momentum. So I don't know. And we're still waiting, but let me put together a poll and y'all let me know. I'm just saying, I'm just simply theorizing. I do not know. Okay. So let me play this and I'm going to put together a poll and see what y'all think.
It's just a nonsensical position, guys. It doesn't make sense. Logically, it's just a nonsensical position, guys. It doesn't make sense. Logically, it doesn't make sense. Rationally, it doesn't make sense. And it's vitally important to the case for two reasons. Reason number one, it exposes a multi-agency cover-up that involves the FBI, the Utah State Bureau of Investigation, the sheriff in Utah County up in Orem and Provo, the sheriff in Washington County who multiple times has gone on the record saying he did not arrive, whoever is the records custodian in Washington County who fiddled around with the tapes and wouldn't give them over to News 2. Like, you're talking about a multi-agency cover-up, potentially the prosecutors, if they try to go forward with this nonsense. That's a bad deal. So that's number one, a multi-agency cover-up. It's a big deal. Number two, it exposes the Fed sloppers. It shows you they're dishonest actors, that they can look at the totality of the body of the evidence and say, yeah, but the only interpretation that supports my position is that Tyler Robinson, 20 hours after leaving his parents, 20 hours after being without a cell phone, 20 hours after not knowing what his parents were doing, 20 hours after not knowing if his parents got in touch with an attorney, 20 hours later is still thinking, well, I think my parents are trying to get in touch with them, but somehow I've divined, in the jail, we have these, the steel toilets, right? Steel toilets just out in the middle of the room. I use it like a crystal ball. I know my parents haven't gotten in touch with Doug Terry yet. I've been looking into the toilet water. I was in there dropping tea leaves into the toilet water and reading the tea leaves. I know for a fact they have not gotten in touch with Doug Terry yet. But Tyler, you haven't talked to them in 20 hours. You haven't talked to them all day Friday. Maybe Doug Terry's sitting out in the waiting room. Well, I looked at the toilet. I saw the floater in there, and I saw the way it was spinning, and that told me that Doug Terry had not yet been contacted, and his office was closed for the night. He's probably one of those lawyers that does the rare Saturday morning office openings, I guess. I don't know. It's a Fed slop problem. And this is a huge part of this case is you have lying sacks of bull butter on the other side. I don't want to name them by name, but you know who they all are. And they sit on the other side and they come through on their little white knights, on their little midget horses, and they do everything they can to support the Fed slop narrative because they know deep down the Fed slop narrative is falling apart. It's absolutely crumbling. It's dying.
All right. So shout out to Up with BM. There was a bullet and a shot not to do. Hold on. There was a bullet and a shot, but not to do what we think it was, a distraction from the microphone. Everyone forgot that part. Someone was on a low-C roof, but would have been from CS shooting. I'm just theorizing. I understand what you're saying. Like I said, I don't think he was shot at all, but this new information does have me thinking. I'm just being real. I'm still waiting on them to come back. Nothing's happening yet. Hold on. Let's see. Nothing's happening yet. Okay, they're not back yet. But I just put a poll. I just put a poll up, and I don't know. So, just for the record, it's just a theory. But let me know what you think about the theory. I think it's worth theorizing. That's all. That's all I can say. That's all I can say. Now that I see that distance, I'm not so sure. That's what I'm saying. It never hit my head that somebody could have been on top of another building that is at a higher elevation, like 20 feet higher than the Losi Center. This right here would make it would make more sense for the 30-06 to go inside of his neck instead of through his neck, and for it to die in his neck versus going through his back. Because with this theory, it would go through his back if it went through and not his neck. So everybody shooting the bullets through the neck of the meat, it would go through the back of the meat if this is something. And the person would have to then shoot from 300 yards away. I don't know. We may have something, y'all. We may have something. I don't know. Recess until 9:45. 9:45. What? Mountain time. Let's see. 9:45 Mountain time is what time Eastern time?
9:45 a.m. Mountain time is 11:45 a.m. in Eastern time because the mountain.
It's 11:57. That's what I was thinking. Like, what the hell? Okay, so maybe they're late coming back, so I'm not sure. But let's see. It's possible. All right, hold on a second. Let's see. So share your thoughts in the poll. So 67% of you guys are saying it's not possible. Okay. All right. And shout out to Upward BM. Upward BM dropped so many super chats. I owe it to him or him or her. Are you a male or female? Up will be him. Let me know. But I owe it to you to read your comments because you dropped so many super chats. So I appreciate you. But I would say to drop it in the super chat if there's anybody else. Like I owe up would be him. Okay. To take it further, Mr. Lego, that's all possible. So who was on the roof at hold on. It was a certain time. I don't know. We know when the person was up on the roof. I think the person was up on the top of the Losi Center before anything happened. Because somebody was like, "Hey, who was up there in all black?" And they were up there, and they were just walking into the courtyard. Remember? So they're just walking into the courtyard when they filmed somebody being up on the roof. So this was ample enough time for them to get up on the roof of the Losi Center and walk across that little area and then climb up on the roof of the other building because there's a walkway. All right, take it further. That is all possible. So who was on the roof? Was it the same guy the cop ran into when he was going up on a Losi Center who he didn't know, who acted the guy that had a badge? Hold on, let's go back to the video. You make a lot of sense. Hold on, you make a lot of sense. I got the video right here. You make a lot of sense. I think it was this right here.
On September 10th, yes.
Which building was that, sir?
I don't recall.
Was that considered a scene that was worth preserving?
Recognizes Utah Rule of Evidence 1102 as an alleged shooting. Is there any footage of the alleged shooting?
There is not, Judge.
Okay, I just wanted to clarify that.
There may not be any footage of the alleged shooting because there's no camera angle that high to show somebody on top of the science building. What if there's no camera angle showing the top of the science building because the science building is way higher than the Losi Center?
Is there any footage of the alleged shooting?
There is not, Judge.
Okay, I just wanted to clarify that. Ms. Nestor, given that additional information and anything further from defense?
No, but I think I'd like to be crystal clear. You asked if there's any portion of this video that captures, and I believe you asked of the actual shooting.
And hold on, let me look at the super chats. Shout out to Upward BM again. If Leo was If Leo was on that building, how didn't they see TR? Who is Leo? Let me know who Leo is. No shared stream today. No, we all are taking turns. So the first day it was Danks and hold on, who was the first day? Who was on there the first day? Well, we on there the first. I did day 2. So I was on there day 2. Me and Jesse was on there day 2, and then Danks and Bays was on there day 3, and then day 4. Do I got the days wrong? Was I on day whatever? But yeah. So now it's I think Jesse and Daily Fredo. I need to look over there and see who's over there. So we're all taking turns being on the live stream together. So it's not all of us all the time, because what happened was, oh, that's right. So day 1, all of us was on there, and it was like annoying because it was too many people on the side. You know what I'm saying? So after that, they just picked times where, so I was on there day 1, I was on there day 2, if I'm not mistaken. And then Bays and Danks was on there day 3. And then, yeah, so that's kind of like what it is. So all of us can't be on one live stream. It just is annoying. It's just too much going on. So that's the reason why I'm not on there. We're all taking turns. So, all right, so let's see if we're back. Damn, they're not back yet. All right, they destroyed evidence because the evidence reveals a different weapon was used, the kind IHOP would use, like those pagers a few years ago. Yes. But I'm sorry. I'm starting to not believe, but understand that the science building situation may actually be what happened. I'm literally starting to think that is what happened. And if that is what happened, Tyler Robinson could not have done that because you had to be a professional to shoot that accurately from over 300 yards away from that elevation. So it wasn't Tyler Robinson. It wasn't Lance Twiggs. It had to be an actual professional sniper. But nobody was up there, and there's no camera angle up there because it's too elevated for anybody to know. But it will make all the sense in the world. So I'm probably going to make that my secondary theory. It's not my new theory yet. Secondary theory. So I said, don't forget the drones, but there's no drone that is accurate enough and powerful enough to shoot somebody in the throat from 300 yards away. Come on. So that's not really a theory. Don't buy this theory. Okay. And remember the handgun theory. See, now y'all just throwing out random theories. The handgun theory, you mean the palm pistol theory? I don't think that's anything either. No. You talking about Rick Cutler? No, I don't think Rick Cutler did the little thing in that right now. I don't agree with that either. No. I don't believe that. But like I said, they're just theories. They are just theories. And make sure to hit the like button. Make sure to hit the like button. All right, let me see. All right, they're not back yet. No, just going through theories that we're around. We're just going through theories, y'all. We're just going through theories. That's the whole point. We're just looking at theories because we can ignore this bullet thing all we want to, but we're going to be looking at this trial and they're going to talk about bullets. So it's like, if we're not going to at least consider the bullet theory, why are we literally looking at this case if we're not going to consider it? Because it will all be null and void in our brains. You know what I'm saying? I just got here. Do you think it was the mic or the 300 blackout round? What do you think? Okay. So here's my thought. I'm still with the theory that it was something that happened here. Okay. Actually, Barron said it was two mics. Barron thinks it's actually two mics. It was a mic here and a mic under his nipple. He said it was two mics. So we all have different theories. You know what I'm saying? So I don't know. So let's see what y'all have said. All right. So is the science building a valid theory that would justify the bullet going through Charlie Kirk's neck? 30% of you guys said yes. 70% of you guys saying no. Cool. So everybody keep voting because let's see. I'm not sure how many people have already voted in the poll, but vote in this poll. I want to see what you guys think. So keep voting in the poll because I want to see. So the poll is still going and we'll go from there. Let's see. All right, we're back. We're back.
This court will take the necessary time to make sure it's given the weight it deserves, and it is deserving of every moment. Put this on the record. Certainly, if either side wishes to be heard about the court's understanding, I welcome your comments. Exhibit 24 was displayed on the monitor visible to the media camera Exhibit 16 was displayed on all monitors and appeared on the live stream for approximately 3.5 seconds. The camera operator redirected the camera before any party called attention to the display of Exhibit 16. Approximately 16 seconds later, the court observed the image and stated, "Let me stop you, Mr. McBride. I'm not sure. Is this being broadcast?" Mr. McBride responded, "Let's take that down." The full text of Exhibit 16 had previously been made public through a search warrant that was publicly available on or before April 2026. The portion displayed on the monitors did not contain the full note and consisted of approximately 78 words. Approximately 15 of those words were included in the information filed on September 16th, 2026. In addition, the full note was read into the record during the preliminary hearing. The court previously ordered that Exhibit 16 be admitted into evidence and permitted its display within the courtroom, but prohibited its publication through the camera used for the live stream. And that concludes the findings of the court as it relates to this issue. Do the parties wish to be heard before we go into what you're requesting about the record on what occurred?
Your Honor, your recitation is accurate. My earlier comments were based on my memory of reviewing this last night. In the recess, I reviewed the feed again, and what you have said today is accurate.
Thank you. Mr. Novak, any?
No, Your Honor, I don't take issue with the court's factual summary.
All right. Turning to you, Mr. Novak.
Thank you, Your Honor. We're going to renew our request to exclude all electronic media coverage from all future proceedings. That was our motion docketed at number 305, and that included video cameras, still photography, and audio. This is the second time that the court's orders concerning the scope of electronic media coverage have been violated. I'm a baseball fan, and I just don't think the court needs to wait for the third strike. 2 strikes is enough. If I may, the alternative remedy, which we think is not wholly adequate, which is why we think it's an alternative and a less desirable alternative, is for this court to both reverse its prior order authorizing electronic media coverage of today's hearing, which we had previously filed an objection to after the court, I would say, preliminarily granted the request for today. That was sort of the chain of events. And that the court proactively preclude electronic media coverage at the last day of the preliminary hearing, which will be September 1st. Now, I understand that there has not yet been a request for electronic media coverage for September 1st, but there is no doubt that there will be, just as this court previously observed that it wasn't prepared to preclude electronic media coverage at the preliminary hearing because there had not been any requests. There were requests, and those that were timely were all granted. The court denied one request because it was not timely for one particular day. So I guess the way it would be is any request for electronic media coverage of September 1st will be denied because that's the appropriate sanction for what happened yesterday.
Put a 1 in the chat, y'all can hear everything clearly. Put a 1 in the chat, you can hear everything clearly.
The exhibit was previously summarized by the state in certain documents which became public because the state didn't take any actions to seal them beyond the 6-month period. The fact that the contents of the exhibit were read in open court is not the issue. The issue is when the court issues an order, everybody must comply with it, and there are reasons for the order. And the reasons, as this court stated, are to protect Mr. Robinson's right to a fair trial. So no doubt that the court balanced those prior ways in which the content of this exhibit had already been disclosed when the court decided that there would not be electronic media coverage. That's a fact that we have all known of that exhibit. That's a fact that we've all been aware of as we've gone along. So to summarize, and then I will stop because I know we still have a witness here. And of course, the court needs to hear from the state and counsel for the media, I suspect, is we would like the court to reconsider its order denying motion 305 and grant it for the balance of all of the proceedings in this matter. Or as an alternative, the court prohibit any further electronic media coverage of the preliminary hearing, which includes September 1st.
Yeah, this is a lot of wasted time.
Turning to the
You're wasting
state,
time
to
for
the
real.
media.
Can we move on? Who cares? Browbeating this man is
remedy.
dumb.
We've heard of instances where the media has been able to delay
Oh my God.
publication of the recordings of the proceedings. We've heard of instances where that has been a short delay of like 30 seconds. I've talked to the media attorney about this, and they do not have the capability to do that right now. My suggestion would be for future proceedings to order the media to look into that capability, and that would be a remedy that perhaps could be used in the future. I think that would be a satisfactory remedy to avoid this type of thing in the future. As to the other remedies requested, we have one witness. The final witness, well, the defense has one witness. That witness is a ATF DNA forensic biologist. And I assume that the exhibits that will be admitted through her will be of that nature. We've already, in fact, admitted the report that she is going to be testifying to. The reports, I should say, that's exhibits 30 and I believe 34. And so I don't think we have, and those have already been published. I don't think we have the same risks or, I'll just say risks with her testimony as we do with some of this other evidence that has already been admitted.
Thank you. To the media.
This whole thing is a joke. They're still whining about the media. We're not even talking about the case.
In a proceeding like this, the parties in the court and the media are working together to learn and to refine their processes. I hear Mr. Novak's remarks about challenges that we've run into in the past. I recall, it hasn't been that long ago, a time when the camera was placed in a location in the courtroom that was causing challenges.
It's as loud as it can be.
There were challenges with
the volume is all the way up, all the way up.
Aspects of the court's ruling. The court reiterated those, and those processes improved. We are getting better at this. Media is on board and recognizes the court's obligation and its significant efforts to balance the interests here.
Yeah, because they don't have a case. I agree.
Including its recognition that the media operator in this case beat almost all of us to the punch, right? And saw what was happening on the screen and moved away as quickly as they could. We believe that the procedures that the court currently has in place, even if they don't, every moment of every hearing deliver the result that we are intending to deliver. Those processes are working. I don't believe that.
That's not me typing. That's them.
Adjustment.
The stenographer typing.
Much less a sanction, much less a revisitation of something that says, let's keep every photographer, every camera out of this courtroom for every proceeding. In light of the court's well-reasoned and exhaustive rulings after long briefing on all of this, the court is currently balancing these interests correctly. And we therefore ask the court to allow the parties to recognize that the time we're dedicating this morning represents a reiteration of the importance of these principles. The media and the parties all recognize that. We'll continue to endeavor at all times to do all that we can to ensure that those are adhered to and let the parties go forward under the current procedures without further order or sanction by the court.
Thank you.
That's the stenographer
Further
typing.
arguments before the court issues its ruling.
No, but thank you for the argument.
Thank you. And just updating my notes as I'm intending to issue this ruling right now. I'm just making sure that I'm capturing all the points made in the argument right now.
Oh, he's the one that's typing. I thought it was okay. He's the one that's typing. Somebody said bad audio. Can you tell me how the audio is? What do you mean bad audio? Let me listen on my phone and see. Well, I'm not going to hear anything now till somebody starts talking. But somebody said the bad audio. What is it? Echoing? Can you tell me what bad audio means? So let me know about the audio. Somebody said bad audio. Somebody said turn it up. I can't turn it up anymore. Is at the highest. Is at the highest. Yeah, the court is just low. Okay, it's not me. I'll back my microphone up a little bit so I won't be so loud compared to the court. Is this better as far as my microphone versus them? I'll talk a little lower. All right, since he's just typing, I'll play a commercial because he's not even doing no but damn typing.
This just in, a new way of healing is sweeping the country, and it's a card game called Like Mother, Like Daughter. This game is powerful.
My favorite question was, if you could parent me all over again, what would you change? This card game has a mother deck and a daughter deck, so we both have questions for each other.
These are some good questions. Do you think I'm a people pleaser? If so, where did I get this trait from?
This card game actually helped my marriage, and the questions showed me that I still had unresolved issues with my mom, and I was taking them out on my husband.
If you don't do anything else, buy this card game. You won't regret it. Click the link below.
Like another light thought, we are the same. You'll see when we play this game.
All right, he's still typing. All right, somebody said, do you think they will not allow cameras because of this? No, the cameras are in there. It's cameras on certain information is the problem. They don't want certain things to be divulged by the court. So certain things we can't see. They don't want us to see certain things. Good question. Mark says, if this is the last day, why bother with all of this? I agree. Great point.
All right.
All right, we're done. No more typing. More typing. Sir, can we keep
I
going?
appreciate the party's patience. This issue rises to the level that necessitates great care. And as my practice, I don't like to rush or make snap decisions. And I want to give this the full
The judge was typing.
analysis that it's due. So thank you again for your patience.
No problem, Mark. I like reading the chats. But make sure to put in the super chat if you really want me to read your question. But I'm reading everybody's comments. I don't reply to everybody's comments that's not in the super chat, but I do read your comments and reply. You're welcome, Karen. Hold on. Karen says Trigger Smart doesn't have the judge up, so I'm skipping through channels. Well, it's nothing to see right now. He's just typing, so I don't know.
Court will issue its ruling on the request by defense. The constitutional rights of Mr. Robinson and Ms. Kirk are paramount. Although transparency in judicial proceedings is a fundamental interest, it must be balanced against the constitutional rights of all parties. Having considered the arguments presented by counsel and having reviewed the events that occurred yesterday, the court finds that its order prohibiting the publication or broadcast of Exhibit 16 by the media camera was violated. The court agrees with the defense. This constituted a violation of the court's order. Compliance with court orders is essential in all proceedings and is of particular importance given the nature of these proceedings. With respect to defense's request as a sanction that the court reverse its ruling on defense motion 305, motion to exclude cameras, the request is respectfully denied. The analysis underlying the court's prior ruling remains unchanged, and the court adheres to its reasoning and conclusions. With respects to the defense's alternative request as a sanction to prohibit all cameras and electronic equipment from today's proceedings, thereby preventing the electronic capture of the proceedings for those inside and outside of the courtroom, the request is granted in part and denied in part. Effective immediately, members of the media shall no longer capture or broadcast any exhibits displayed by the parties during today's proceedings. The court finds this sanction to be proportional and appropriate in light of the violation of the court's prior order. The court reserves this sanction as it relates to September 1st. It is not before the court. There has not been a request for electronic media coverage, and the court won't issue a pre-ruling. When it becomes, that request has been filed and all the deadlines which the court has imposed in regards to the MC filing are in place, if motions are filed, the court will entertain motions in brief argument ahead of the September 1st hearing and address it at that time. This is the ruling of the court. Thank you. Turning to the defense, if you wish, you may call your next witness.
We would like the benefit of the record before we start taking evidence today.
Yes, Mr. Gernander, and I'll allow all parties, given the ruling of the court, briefly.
And I'll be brief, Judge. And this is in relation to the continued taking of evidence today. And I'll start my statement, Judge, with something that was very insightful that you said the other day. You mentioned, and I quote, "Sometimes you need to take time to save time," close quote. And so that's my purpose for standing up here this morning. We have spent the better part of a day, a little over 5 hours, I believe, hearing from witnesses that the defense has called at this preliminary hearing. And no doubt the defense is entitled to call witnesses at a preliminary hearing as allowed by the rules. But I think it's important that the court remind all parties about the purpose of this hearing. This is a probable cause hearing, as Your Honor has repeatedly stated. The defense has invoked the term reliability many times. And the court, frankly, has found the evidence that's been admitted, the testimony. As a gatekeeper, the court has found it reliable. It's been presented. The exhibits have been found reliable. So any questions of additional reliability are really questions of credibility of the witness and weighing of the evidence. And that is not really what this court engages in at the probable cause standard. And so this is all couched in the context of a likely forthcoming standing objection that the state may lodge if the testimony is long and drawn out and exceeds the scope of the preliminary hearing, gets into areas of a 702 hearing, possibly even trial. We will lodge this objection, but I wanted to just simply state the authority, Judge, behind our objection if we do make that.
As your court is well aware, the magistrate at this stage of the case must view the evidence in the light most favorable to the prosecution. And that's cited to in a number of Utah cases, to include State v. Schmidt. Schmidt continues, this means that when reasonable inferences from the evidence cut both for and against the state's case, the magistrate lacks the discretion to choose between them and must leave such a determination to the fact finder at trial. A few other cases I would like to refer the court to. State v. Pledger, which is a Utah 1995 Supreme Court case. Speaking of this standard, the court says, the standard bars the magistrate from requiring the prosecution to address or even eliminate alternative inferences that could be drawn from the evidence in favor of the defense. So even assuming the defense scores points today in calling these witnesses, again, the court cannot really weigh those in favor of the defense. State v. Hester, which is a Utah Court of Appeals case 2000, where there is conflicting evidence, quote, the magistrate may not sift or weigh the evidence, but must leave those tasks to the fact finder at trial. Of course, we're not at trial yet. State v. Virgin, a Utah 2006 Supreme Court case. And the magistrate may only disregard evidence at a preliminary hearing if it is, quote, so contradictory, inconsistent, or unbelievable that it is unreasonable to base belief of an element of the prosecution's claim on that evidence. There's a State v. Drozbecki case, which is a Utah Court of Appeals case 2010. Magistrates may only disregard or discredit evidence that is wholly lacking and incapable of creating a reasonable inference regarding a portion of the prosecution's claim, but must leave all the weighing of credible but conflicting evidence to the trier of fact. And finally, State v. Lopez, a Utah 2020 Supreme Court case. Speaking of this probable cause standard at a preliminary hearing, the court said, under this low bar, it may be difficult for the defense to overcome a prima facie showing of probable cause. Even an alleged victim's recantations may sometimes be insufficient, given that the magistrate must view all evidence in the light most favorable to the prosecution and draw all reasonable inferences in favor of the prosecution, close quote. Judge, Your Honor has heard 4 days of testimony now. The evidence is overwhelming. It's devastating. And the question needs to be asked, the purpose of continuing with testimony if it's long and drawn out. Of course, the defense has the right to call witnesses, but it needs to be within the context of this preliminary hearing. So again, we may be lodging a standing objection of relevance and exceeding the scope of this hearing. That's my record.
Thank you, Mr. Grunander. Do other parties wish to be heard as it relates to Mr. Grunander's statement? To the defense?
I'm not sure what was being requested by Mr. Grunlander. As I indicated to the court during the testimony of the last witness, we had discussion with the state prior to the start. We had a scheduled date for the court to rule on objections. And the purpose of that hearing was so that we wouldn't have to fly witnesses out from the East Coast if there was going to be a standing objection. Prior to that hearing taking place, the state contacted us after they had participated in interviews of Ms. Oliver and the other experts, and indicated to us, and we indicated to the court, that there was going to be no standing objection to the testimony of these witnesses. So if he's lodging a standing objection now, I think he's waived it, or he should be stopped from asserting it given the circumstances. I didn't hear that he was asserting that, and I intend to keep this next witness focused on the issue that I think is relevant, which is the state presented DNA reports through a non-expert. They selectively read into the record a portion of those reports, which left an extremely misleading impression of the significance of that evidence. So I have the author of the report here, and I'm going to hopefully educate the court on what the limitations are of the report, and that's it. I hope to be done with the witness by noon, direct and cross, and that will be the end of it.
All right, thank you, Mr. Burton. Before I have you call the witness, just want to make sure that the media had well, I'm not sure if the media needs to be heard on Mr. Grunander's response. All right, thank you. All right, Mr. Burt, you may call your next witness.
Thank you. Call Miss Oliver.
Ms. Oliver, if you'd like to come forward and be sworn in.
You do solemnly swear that the testimony you shall give in the case now pending before the court will be the truth, the whole truth, and nothing but the truth. So help you God.
All right, ma'am, you may be seated. And there's a water bottle to your left if you wish. And after you're seated, if you wouldn't mind adjusting that microphone, bringing it close to you to pick up your testimony from today. Mr. Burt, your witness.
Thank you. Could you tell us your name, please?
Caitlin Oliver, Oliver.
And Miss Oliver, could you bring that mic a little bit closer? So I want to make sure your voice is projected. Thank you. What do you do for a living?
I work for the Bureau of Alcohol, Tobacco, Firearms, and Explosives as a DNA section chief.
And how long have you held that position?
I've been a section chief since January, and I've worked with the ATF for about 9 years. Prior to that, I was a forensic biologist.
And where were you a forensic biologist before you started to work for the ATF?
Prior to the ATF, I worked for Jefferson Parish Sheriff's Office in New Orleans, Louisiana, as a DNA analyst and a DNA quality manager.
Back in September of 2025, what were your duties and responsibilities?
I was a forensic biologist.
And do you recall that around September 11th, you received a request to do some DNA work at the request of the state of Utah?
Yes.
Could we display State's Exhibit 30, which is in evidence?
What happened? The audio just went out for some reason. I don't know why. The audio just went out, so I'm just waiting. Why did they cut the audio? Let's see. I just want to make sure. So I'm just going to check something.
And draw all reasonable inferences in favor of the prosecution.
Why did the audio go out?
In favor of the magistrates may only disregard.
So I want to see if they said something that I didn't hear. So what happened?
Report here, and I'm going to hopefully educate the court on what the limitations are of the report, and that's it. I hope to be done with the witness by noon. You received a request to do some.
The audio went out. I don't know why, y'all, but the audio is out. I don't know what's happening. So it's not me. They asked for the audio to go out. Let's see. So they asked for the audio to go out. So why and how long are we going to have to wait? So let's see what's going on over there.
Gonna be late. They brought DNA again.
Yeah, the audio's out. They banned the audio. So my question is, how long are they're going to ban the audio? So we're just going to sit here and look at them talk? This is crazy.
He's not looking over at her. Okay, he finally just did. I was gonna say he hasn't even looked at her or the defense in like 2 minutes. He's like, Mrs. Kirk, please do not text me during trial. Allegedly, I'm just kidding.
For instance, the next sample down.
All right, here we go.
2, where the state read paragraph D, admitted paragraph F, you state in F, based on this calculation, there is evidentiary support for the inclusion of Tyler Robinson, correct? As a possible contributor.
Correct.
Mr. Burt, I just want to interrupt.
Sure.
I was made aware of a question about the media as it reflects this order. So the question was whether audio could be transmitted, and my ruling covered the video display of any exhibits. And so I just want to make sure that's the understanding of all the parties, that the audio of your portion discussing evidence is that you understand that that's going to be captured by the camera and displayed, but not any exhibits displayed. Is that your understanding?
That is my understanding of the court's ruling, yes.
And to the state?
Yes.
And to the media?
Yes, Your Honor. There might be concern about the actual monitors, the counsel table and podium. Any clarification on that?
Well, that's why I give my notation to begin the morning that the parties are responsible to monitor their monitors. And that's there because they're entitled to view it, but they're responsible to ensure that the monitors, as the camera is picking up the courtroom, it's directed not to focus on the monitors, but inevitable capture may occur. And that's why that instruction is given.
Your Honor, Jeff Nyman on behalf of the victim representative. We cannot see the court from where we are sitting, so I don't know if there's a way for us to view the monitor.
I don't understand what you're saying.
It's not being published on this
It's not
one.
being published on the monitor to the court's right.
Right. The order of the court based as a sanction is no exhibits will be displayed.
In the courtroom entirety?
As it stands right now, yes, that's correct. Okay, please approach the lectern.
Your Honor, it's just hard for the victim's family to be able to follow the evidence if everyone but the victim's family is able to view the exhibits here in court.
Exactly.
Thank you. I appreciate your concern. This monitor is not on either. So it's only the attorneys. The attorneys have a right to view what exhibits are being displayed, to make their motions, objections, and to see it. It is the court's discretion on what's displayed in the courtroom for publication, and the court issued a sanction given the events of yesterday, and that's the court's ruling.
Your Honor, I just asked the court to consider the victim has the right to be present, obviously, at the hearing. And the presence without being able to see the exhibits, again, it's our position, is not meaningful.
Thank you. I appreciate your concerns. Mr. Burke.
Could you redisplay exhibit 30, please? And again, while he's doing that, that same conclusion where you include the language, go back to that page, please, 5. Use the term, there is evidentiary support and possible contributor. I want to focus your attention on the words evidentiary support. We've had a prior witness testify that from the FBI testified that they use a scale and they characterize the support along the lines of strong. Are you familiar with that type of a scale?
Yes.
Does your agency employ that scale?
We can come to 5 conclusions at our agency. So there can either be exclusion, limited support for exclusion, uninformative, limited support for inclusion, and support for inclusion.
And I take it from what you just said, you don't use these qualifiers strongly. The word strongly include things of that nature.
Yes, we don't use a verbal scale at our laboratory.
Is that a scientific phrase when you talk about instead of saying that there's support for an inclusion, you instead say there is strong support for the conclusion?
So our laboratory doesn't use a verbal scale due to the fact that they add subjective words to the front of this word support. It is our stance that the likelihood ratio statistic, the number stands on its own. So we report the likelihood ratio and either support for inclusion or support for exclusion.
Thank you. Would you go to page 8 of the report and highlight the very top of the first 2 sentences? You included this language in your report, correct?
Correct.
And in fact, you included this language in all 3 of your reports, referring to the conclusions conform with the relevant Department of Justice policy on uniform language.
That's correct.
Right. And why do you include that language in all 3 of your reports?
It's standard language for our reports. Our reports adhere to the DOJ Ultra statement.
Okay. And could you go now to Exhibit Oliver 4 for the witness only? Not admitted yet. Are you familiar with this document, the Department of Justice Uniform Language for Testimony and Reports for Forensic Autosomal DNA Examination using probabilistic genotyping systems?
Yes, I am.
Right. And would you go to page 4 of that document, please? And the court has heard some prior testimony about this Department of Justice directive. What is ATF's, what is your understanding of what the qualifications and limitations are that are required by this policy of the Department of Justice? What are you not supposed to be saying in connection with the reports that you wrote in this case?
There's a few things that the Ultra document states. First, it states if you use a verbal scale, which we do not, then you need to use the one dictated in the document. This is in an effort to unify the language coming out of DOJ laboratories. It also says that we cannot state that our evidence is infallible, nor can we state that there is a inconclusive result.
Shall not state that it's infallible or have a 0 error rate, correct?
Correct.
It also states, does it not, that you shall not assert that a likelihood ratio of any magnitude provides an absolute identification or source attribution of an individual to an evidentiary sample.
Correct.
And are your reports in conformity with that? You're not stating or implying that anything you did here is asserting an absolute identification of someone as the source of any of the evidence that you examined, correct?
Correct. With forensic evidence, it's impossible to state with 100% certainty anything. That's why we report a likelihood ratio, to speak to that uncertainty with a statistic.
All right. And would you go to the next page of that document? This policy requires that you not state or use the expressions reasonable degree of scientific certainty, reasonable scientific certainty, or similar assertions of reasonable certainty. You didn't do that in any of your reports, correct?
Correct.
You're not asserting anything with respect to any reasonable degree of scientific certainty.
Correct.
Correct. Now, when you can take that down, when did you first receive the assignment in this case?
I would have to refer to my case record to know the exact date.
Do you have those in front of you?
I do not.
Okay, let me pull up Oliver 3 for the witness only. And go to the 3rd page. Does that 3rd page help refresh your memory on when you may have received this case?
Yes, on September 12th, 2025.
Okay. Is that when you first started doing work on the case, do you think?
Yes, it is.
Now, prior to doing work on the case, did you receive permission from someone to consume any samples in the case?
Yes, I did.
And could you go to page 15 of those case notes, please? Again, for the witness only. Do you recognize this email?
Yes, I do.
And can you tell me what the email is and what information it conveyed to you in connection with your examination?
Yeah, so it's standard procedure at our laboratory that when we receive a case, we request permission to consume from the agent. We request that they reach out to an attorney if one is assigned. In this case, we will not begin any work on the case until we've received that permission to consume. So this email is us receiving permission to consume the samples and move forward with testing.
Now, does your policy have, does your lab have a policy for preserving samples for independent testing by the defense?
Where possible, we will not consume samples where it's possible.
And that policy is a longstanding one, not only in your lab, but pretty much everywhere in forensic DNA analysis, right?
That's correct.
Goes back to 1996, does it not, when the National NRC recommended a policy that samples be split wherever possible at the front end of the analysis to allow for independent examination.
Where possible, yes, that's correct.
Right. And they did that because it was their conclusion, was it not, that a wrongfully accused person's best insurance against a possibility of being falsely incriminated is the opportunity to have the testing repeated. Such an opportunity should be provided whenever feasible.
Correct.
Okay. Could you now go back to Exhibit 30? Page 8. Were certain DNA samples consumed in your analysis?
Yes, they were.
And for the record, are those listed on page 8 of your report?
Yes, they are.
Which samples were entirely consumed in your analysis?
That would be exhibits 1.4, 1.6, 1.9, 1.10, 1.12, 2.1, 3.1, 4.1, and 5.1.
Okay. Then are there a number of samples listed above there in the report where you say the DNA extracts will be retained? And then you list 1.1, 1.2, 1.3, 1.5, 1.7, 1.8, 1.13, 7.1, and 8.1.
Correct.
Does that mean that those are all swab samples, correct?
They were swabs, yes.
All right. Does that mean, does your report mean that you consume the swabs, but you have some liquid extract remaining as to those samples?
Correct.
Now, are all of the samples, let's talk about the samples in Plaintiff's Exhibit 30. Were all of the samples you looked at there mixed samples?
I refer to my tables in my report.
Sure. Go to page 2, please.
And can we go to page 3 and 4?
3 and 4, please.
With the exception of the known samples from the known individual, that was a single source sample, but otherwise the evidence samples were all mixtures.
And in many cases, they were mixtures of sometimes 4 and 5 people, correct?
Correct.
Now, when you look at mixtures, such as the ones in this case, you use terms like major and minor contributor, right?
Correct.
Is that language meant to convey that anything with respect to activity of anybody who might be assigned to that DNA weight? In other words, are you saying the person you label as a major contributor was engaged in any sort of activity? Is there any connection between the use of that language and activity?
None of the testing that I performed could speak to activity or what activity led to the deposition of the DNA.
So nothing in your report, if somebody reads that and says, oh, this one says this person is a major contributor, you're not commenting on anything about the person's activity, correct?
Correct.
And is it true also that there are also several other limitations concerning the language of your report that it's important for courts and people who are reading the report to understand?
I'm sorry, what was the question?
Are there other limitations in addition to the one we just reviewed that it's important to understand about the language you use in your report?
In terms, is there something specific that you're?
Yeah, there is. Could you go to Baker Exhibit 30, page 1, for the witness only? Are you familiar with this publication?
Yes.
This is a publication by the National Institute of Standards and Technology called Forensic DNA Interpretation and Human Factors.
Correct.
This is put together as a guidance document for practitioners on what to simplify, essentially what to say and what not to say.
I don't know that I would call it a guidance document. NIST is not a regulatory body for DNA testing. It was a report that looked into forensic DNA reporting and specific human factors that could affect our testing. So they may have had recommendations, but as far as them being a regulatory body that's issuing guidelines, I wouldn't state that.
Okay, that's fine. Could you go to 136, please? $136. This is Baker 30. Keep going. There we go, right there. Wait, 135, I'm sorry. And then scroll down to the next page. So they're making recommendations here as to how the report should be worded, correct?
Correct.
Let me ask you whether you agree with some of these limitations, or they call them caveats. They talk about how you describe the number of contributors, and they say the true number of contributors of DNA to an item can never be known. Do you agree with that?
Yes.
Okay. They also say, let me ask one question before I ask.
Yeah, I heard
this
that,
one,
right?
Which is, do you use something called a reporting cap in all three of your reports?
Yes, so for our likelihood ratio statistics, we cap the statistic at 1 trillion. The actual number could be a lot higher. It could be quintillion, octillion. We chose 1 trillion because it has meaning, I think, to people that can understand what 1 trillion is. An octillion and a quintillion gets a little high at that point. So we cap at 1 trillion.
And they talk here, do they not, about how you convey the idea of a reporting cap? And they say the LR reporting cap was chosen because of the limitation of biostatistical modeling and independence assumptions of STR loci. Do you agree that that's why the cap is chosen?
I believe we chose our cap for the reason I stated.
Do you disagree with that statement in terms of why the cap is chosen?
I'm not familiar with the paper that's referenced there, so I would have to familiarize myself before I said I
Okay.
agreed or disagreed.
Fair enough. And then they also suggest that you alert in your report that profile descriptors cannot be applied to activity level issues. Do you agree with that?
Yes, so this is what you were stating about calling a major contributor. It doesn't speak to the activity that led to the DNA deposition.
Right. DNA profiles may be described as major, minor. However, these descriptors should not be interpreted in the context of a decision regarding the nature or the mechanisms, actions, or timing that led to the deposition of the DNA. You agree with that?
Correct, yes.
All right. And then the other sort of limitation, convey that the DNA results cannot be interpreted as the analyst providing an opinion regarding who the source of the DNA is.
Yes, so this is once again, we don't make source attribution statements. We will say there's support for inclusion, and then we back up that with a statistic.
So from a scientific standpoint, you couldn't read the paragraph that sets out the likelihood ratio in your report, whatever the number, and then blast a headline in the media, Mr. Robinson's DNA is found on this item. That's a source attribution, is it not?
Correct, yes.
And that would not be scientifically defensible, would it?
Correct.
Okay.
Good point. Good
Another
point.
limitation they talk about on likelihood ratios on the next page, please, 137. Likelihood ratios cannot speak to the likelihood of a proposition, only to the probability of the results given a pair of propositions.
That's
Do you
it.
agree with that?
Yes.
That's it.
Explain that, because that's a little
discrediting her.
above my pay grade in terms of understanding.
So a likelihood ratio statistic compares the probability of the DNA profile of the evidence given two competing hypotheses or two competing scenarios. Typically, the first is that the person of interest is included, and then the exclusionary hypothesis would be that the person of interest is excluded. So there's a random, unknown, unrelated individual contributing.
And when they're elaborating on that point, they say a likelihood ratio indicates if and to what extent the DNA analysis results support one proposition over another. It is not possible on this basis alone to determine which is the most probable proposition. Do you agree with that?
Yes.
Yes.
Okay. And then the next limitation they suggest you convey is that convey the DNA statistics cannot imply uniqueness within a population. Do you agree that that's a legitimate limitation?
Yes.
And explain what that means. Does that go back to the issue of source? You can't assign a source to a DNA sample?
Correct.
Okay. It says you should delineate the meaning of a verbal qualifier, but you didn't use one in this case, right?
Correct.
This is the prosecution's witness, as far as I know. Y'all correct me if I'm wrong.
That your testing cannot, and correct me if I'm wrong, I don't mischaracterize it. Your testing, none of the testing in any of the three reports can answer the question of how and when DNA got deposited. Is that true?
That is true. DNA can't speak to the activity that led to the deposition of the DNA.
And the report says, with regard to that issue, with the increased sensitivity of DNA techniques and sophisticated software, a DNA profile may be developed even when the contributor of that DNA never touched the item or area that was swapped. Alternatively, a person's DNA may be present when they were not involved in the crime. Do you agree with that?
Yes, once again, I cannot speak to the activity.
Can you explain how it's possible that a DNA profile may be developed even when the contributor of that DNA never touched the item or area that was swapped?
So it's possible if, say, the pen that you're sitting there using for the week, you say hand it off to the judge, and the judge then touches it for a period of time, and then I swab it. It doesn't speak to who handled it last. I could test that. I could get both of your profiles. I wouldn't know which person was the last person to handle that item.
All right. And similarly, if you had a lot of DNA on your hand, we shook hands. I then went to pick up an exhibit, a gun. I touched the trigger of it. Your DNA could be on that trigger, right?
It is possible, yes.
Okay, even though you never touched the gun.
Yes.
And that's why, because of those possibilities, you can't make any assessment of how or when DNA got deposited, correct?
Correct.
How long can DNA persist on an item?
DNA is quite stable over time. It can be broken down due to environmental insults. So things like heat and humidity are known to break down DNA over time. But I couldn't give you an exact number.
Were certain of the samples that you tested in this case degraded samples?
There was degradation present in some of the samples.
And what can cause degradation?
Like I said, there's environmental insults, heat, humidity.
Now, the second report that you wrote had to do with a Dremel item that was taken from Mr. Robinson's home.
Correct.
And did you request certain what are called elimination samples in regard to items that were recovered from his home?
Yes.
Tell the court what an elimination sample is as opposed to a sample that relates to what's called a POI, person of interest.
So an elimination sample is a sample taken from a known individual that it may be assumed that they could have come into contact with it. If I were to say swab your vehicle, then I would want your DNA sample as an elimination to eliminate you in order to look for any additional DNA that may be there.
And you say they're assumed contributors because depending upon the location, for instance, somebody's house, you would expect if there were multiple people in that house that perhaps everybody in the house could contribute to a certain DNA result.
It's possible.
So you'd want samples from all those folks to see if they contributed to an item that would be associated with a place where they congregated.
Correct.
And I noticed from your case file that you also requested, but I don't think you received, elimination samples from agents who were involved in this case.
Correct.
Why do you request those samples?
The type of testing we perform is quite sensitive. And so it is a standard practice that we request elimination samples from any of the investigators involved in order to potentially eliminate them in case they could have contaminated the evidence.
Okay. Now, in report number 157, if you could bring that up, please. Oliver 157, which has been admitted. The elimination samples that you requested in connection with items seized from Mr. Robinson's apartment were from Amber Robinson, Matthew Robinson, and Lance Twiggs, correct?
Correct.
And that's because you had information that those people were associated with the house.
Correct.
And when you tested or compared, first of all, you determined their DNA types, right?
Correct.
Then you compared their types to what you found on the evidence.
Correct.
And for a certain number of those samples, you found the presence of DNA of your elimination samples, not because they were suspects, but because they were associated with the premises, right?
There was support for inclusion of some of these individuals, yes.
Okay, and if you could scroll down to page 4, which is the table, I just want to review briefly with you. For instance, item number 1.4.
Who does she work for is a good
which
question.
was a swab from the rifle. You used the elimination sample of Mr. Robinson's father, and you found his DNA on that particular swab, correct?
I would say there's support for inclusion of Matthew Robinson on the sample obtained from the swabs of the bolts of the rifle.
I'm glad you pointed that out. That's, again, consistent with your other testimony. You're talking again about support for inclusion as a possible contributor.
Correct. And there
Again,
would-
not because he's a suspect, but because he's associated with that premise.
Correct. And there would have been a likelihood ratio statistic calculated and to go along with that.
Okay, could you go to the next page? Similarly, with respect to 1.6, you found, again, Matthew Robinson on swab number 1.6, or a profile that indicated he was a possible contributor.
There's support for inclusion of Matthew Robinson.
Okay. And next page, actually go to page 7. You found support for inclusion of Lance Twiggs on swabs of buttons of a Dremel tool, correct?
Correct.
And going back to what we were talking about before, if a person named Lance Twiggs lived in that residence, came into contact with Tyler Robinson, and then touched a button on a Dremel tool, you'd expect Mr. Robinson and Mr. Twiggs's DNA to be on there, right? Or you could.
It's reasonable to assume that anyone living in the household could have contributed to DNA on an object found in that household.
And similarly, you found profiles to suggest support for inclusion of Mr. Twiggs on other areas of the Dremel tool, correct?
Correct.
Okay. Now, the last area I want to ask you about is, you're familiar with something called NGS?
Yes.
What is NGS?
NGS stands for Next Generation Sequencing. It's a DNA technique that sequences your DNA. So it looks at the individual sequence of your DNA.
And is it true that in your field, that whole area of NGS is something that's at the forefront of everybody's attention? For instance, when you go to seminars and you look at the presentations, there's a lot of talk about NGS, right?
That's correct. Yes, it's a newer technique.
And is it being developed by ATF as a technique that's going to be used or has been used?
Not at this time, no.
And is there plans to do that?
Not at this time, no.
Okay. Do you know if other labs have implemented it?
I believe there may be some laboratories in the United States that have it in use, but I wouldn't have direct knowledge of that.
Now, you used a program in this case called STR Mix, correct?
Correct.
And that's sold by a company in New Zealand, that software?
Correct.
Have they developed another program called STR Mix NGS?
I'm not aware of NGS software.
Could you go to 156, Oliver 156? Let me know when you're there.
Hey, y'all, I'm just going to let y'all know. I can't do this. Do y'all know
Are
that
you
they
aware
never,
that STR, the developers are selling a product called STR Mix NGS?
I was not aware, no.
they never cross-examined Lance Twiggs? I just thought about that. They never cross-examined Lance Twiggs. Why are we talking to her and they never had a chance to cross-examine Lance Twiggs? They got her back up on the stand. I can't do this. I can't do this.
Okay. Now, sequencing analysis is different than what you did in this case, correct?
Correct.
And how so?
As I said, sequencing is looking at the individual sequence, the individual bases that make up your DNA, as opposed to the testing that I'm performing, which is looking at length variations. So STR testing, which is the testing I perform, looks at areas of the DNA that are known to be highly variable between individuals. And there are areas where the DNA sequence repeats itself over and over again. And depending on who you are as an individual, you may have a different number.
I'll stay as long as I can, but if we're not going to talk to Lance Twiggs, like, what are we here for? Like, we talked to this DNA lady for like an hour 2 days ago. What are we doing?
Number of repeats present at that location. So the testing we're performing.
Only. You're familiar with this chart?
Am I wrong for saying that?
Okay, this lists all the alleles that you found for all the testing in your 3 analysis, correct?
No, it looks like.
No, you were right, 154.
Well, he was given
This is
immunity
one-
from cross.
What's the exhibit on this?
Immunity means I don't have to
Okay.
go to jail if
You're
I say
familiar with
something
this chart, right?
incriminating. Not
I've reviewed the first page of this chart. I have
Sure.
not reviewed the entire
Go to
thing.
the first page. This lists the alleles that you found, correct?
For the known samples, yes.
Okay, now go to the second page.
That's the reason why
And
I'm
is it
here,
true that
because
for
I
the
thought today
alleles
was
of
Lance
interest in
Twiggs
this
Day.
case, one of the alleles of interest is at the D3 location, allele
Sorry for
17.
interrupting, but I don't even care about what
One
he's
of the
what he's saying.
locations that we look at on the DNA strand is called D3. That's a location, yes.
Right?
I thought
And in
today
this
was
case,
Lance
the
Twiggs
17
Day.
allele is important because Mr. Robinson had a 17 allele, correct?
Correct.
And some of the evidence
this is a different
had
lady.
17 allele
Correct.
at that location.
Correct.
She's saying the same
So as
stuff.
I understand the way you do this, you look and compare whether those are the same number, basically.
I wouldn't state that's how we do our comparison. So it's not just number matching. We're using STRmix, the StarMix software, in order to perform an analysis of the software that looks at the possibilities for a DNA profile and make comparison to the knowns that way. We aren't using a chart and just doing number matching.
Yeah, and I wasn't suggesting you did, but you're looking at the alleles and measuring the peaks, and it's a fairly sophisticated process, correct?
Correct.
But the bottom line is you're comparing alleles one against another.
Correct.
So if a person is a 1717 and the evidence sample is a 1717, you're looking at that comparison.
Correct.
And again, measuring only length.
Correct.
But it's true, is it not, that researchers have found that that particular allele, the D317 allele, that there are actually 3 different 17s, 17A, 17B, 17C.
Yeah, so there's something known as isoalleles. What that is you may have, in this case, a 17 allele, but the sequence within that 17 allele is different. So 2 people may have a 17, but they may have a different sequence within their 17 allele.
And it's been found that there is a 17A, a 17B, and a 17C, correct?
Objection, relevance to the probable cause hearing. At this point, I think we've once again gone beyond probable cause, and based on Mr. Grunander's argument, I would invoke his argument here in the case law that he referenced, and I object to this question.
Let me withdraw the question, reframe it, and move beyond it.
All right, so I'll sustain the objection. It will be reframed and we'll go from there.
It's true, is it not, that at least 1, 2, 3, 5 of the locations of interest in this case, researchers have found that the alleles that you were looking at, these isoalleles, have different sequences but the same length.
Objection. Relevance. The witness has testified she does not do sequencing analysis here, and that's what the question
Of course she
is asking, is
doesn't.
about sequencing analysis.
Counsel?
The point, though, is that her testing cannot distinguish between these isoalleles, and therefore it goes to the weight of the comparisons.
But if she didn't do that,
Yeah, that's the point, is that she didn't do it, and therefore she's not in a position to draw conclusions.
Mr. McBride?
That proffer is inaccurate, that she's not able to draw conclusions because she did not do NGS or sequencing analysis. She has testified that her lab and the analysis she did here is not sequencing analysis, it's something different. Whether or not she could do sequencing analysis is irrelevant to the analysis that she did do. If Mr. Burt wants to call an expert to say sequencing analysis is better or something like that, that's fine. But this expert does not do sequencing analysis. Therefore, the line of questioning that goes into sequencing analysis is irrelevant to her testimony.
Let me see if I could lay a further foundation.
All right, so I'm going to sustain the objection. And the question may be re-asked if counsel chooses.
When you do your analysis using length only, do you go by the rule that if any STR locus fails to match when comparing the genotypes between two or more samples, then the comparison of profiles between the question and reference sample is usually declared a non-match, regardless of how many other loci match?
No, it's not quite that simple. What you're speaking of is an exclusion, is that correct?
Yeah, right.
So it's possible for DNA evidence we spoke about, it's possible that DNA evidence be degraded. In a case like that, there may be the potential that some of the profile has what we call dropped out. So it's not present. In that case, we wouldn't expect necessarily to have a inclusion or exclusion at that location because there's no information present there. So it's not quite as simple as is every allele in this chart present in the evidence. There's more to it than that.
If you had a difference in sequence between a known and a question across many loci, would you exclude the person?
It depends.
Again, objection, Your Honor. We're going back into sequencing, which is not the analysis that was done in this case.
Mr. Burt?
Again, Your Honor, if there could be an exclusion based on this and the testing was not done, I think that is relevant.
But as it relates to this witness and her firsthand knowledge, I'm not seeing that tie-in as it relates to her.
All right, let me move on then.
So I'll sustain the objection.
Now, you said that all the samples you looked at in that one report were mixtures, correct?
Correct.
And the number you get in the likelihood ratio depends on how many contributors you estimate, right? The number is going to vary if you say I think it's a mixture of 2 people versus I think it's a mixture of 5 people.
It's not necessarily the number of contributors. The likelihood ratio speaks to the weight of the evidence. And so it's comparing known individuals to the unknown sample. It could be a low number and be a single source sample. It could be a high number and be a 4-person mixture. It's not necessarily directly correlated with the number of contributors.
Let me ask you if you agree with this. This is from the NIST mixture study. A likelihood ratio numeric value is not a measurement of a physical quantity. Do you agree with that?
Correct.
Rather, it is a ratio of probabilities in the opinion of the expert assessing the likelihood ratio and is dependent on the specific propositions used to formulate it and also on the individual making the assessment.
Correct. Yes, I agree.
And does the final likelihood ratio depend on the number of contributors you assume?
No, it does not.
It has no effect whatsoever.
It can have an effect. It's possible. It's possible multiple other factors could contribute to the likelihood ratio.
Is it somehow difficult to figure out how many contributors there are in a sample?
I guess I would say that I use my my training, education, and experience in order to determine the number of contributors present in a profile.
I noticed throughout your report, you use the phrase, for instance, with regard to the 1.2 sample, the profile consistent with at least five contributors, at least one of which is male. And for 1.1, you say the profile is consistent with at least 4 contributors. I assume by the word at least, you're signaling that it could be more.
Correct.
And as the number of people to a mixture increases, the difficulty in sorting out that mixture increases as well, correct?
Correct.
I noticed in your standard operating procedure, there's some guidance on interpreting 3-person mixtures. Familiar with that, right?
Yes.
And it says, and correct me if I'm wrong, approximately 70% of 4-person mixtures present as 2 or 3-person mixtures based solely on number of alleles present.
It's possible for them to present. Yes.
Well, it doesn't say it's possible. It says, for example, approximately in all cases, assuming a mixture as a result of the combination of 3 people must be done with caution. For example, approximately 70% of 4-person mixtures present as 2 or 3-person mixtures based solely on number of alleles present.
You said you're referencing my SOP?
Yes.
Is it possible for me to take a look at it?
Sure.
Your Honor, I'm going to object at this point. The point that defense counsel is getting at is made in the last answer, which is that the difficulty of sorting out mixtures increases as the number of contributors increases. That's all understood, but that has nothing to do with the probable cause determination. Even if it's difficult, the inferences and the evidence is weighed in favor of the state. The court cannot weigh the difficulty in determining this evidence. Is it fair for a trier of fact at a jury? Sure it is. But we're now getting into weight issues that are relevant for a jury, but not for this court.
Well, he's implying there's going to be an extended discussion. I have one question which he wants to look at her manual to make sure it's in there. So, and then I'm done.
All right, I'll allow this question, so I'll
Thank you.
overrule the objection. She may review the material and
So could you bring
question
up
could be rephrased.
one exhibit, Oliver 148? This is your SOP document, correct?
Correct.
And then go to page 83. Did I read that correctly?
Yes.
And so it's true, is it not, that approximately 70% of 4-person mixtures present as 2 or 3-person mixtures?
It's possible.
Thank you. That's all I have.
Thank you. We've been going for a bit, and depending on how much cross, I'm trying to decide if a break is warranted or if, Mr. McBride, you wish your cross is limited. Again, not trying to say which way you should go. I'm just trying to weigh whether we should take a break.
I will probably be, I'll probably be 20 minutes.
All right, let's just keep going, and then at that point, we can take a break. Thank you, Mr. McBride.
Good morning.
Morning.
Is your lab accredited?
Yes, it is.
What does that mean?
So our laboratory goes through a voluntary accreditation process where a external third party comes in and audits our laboratory to a set of standards. Specifically, the ATF laboratory is accredited, and specifically the DNA section of the ATF laboratory is accredited to 2 sets of standards. One is an international set of standards called ISO 17025 for testing laboratories. And additionally, a DNA-specific set of standards put forth by the FBI.
Does the accreditation require that the methodologies you use be validated?
Yes.
The methodologies used in this case have been accepted by courts across the country, correct?
Correct.
Does the accreditation require that forensic biologists like yourself satisfy certain qualification standards?
Yes, we're required to perform competency testing prior to participating in casework. And additionally, we participate in twice a year proficiency testing.
And do you satisfy the competency and qualification standards required by accreditation?
Yes.
And at the time you did the testing in this case, did you satisfy those standards?
Yes.
Moving to your opinions, where on the firearm did you find evidentiary support for the inclusion of Tyler Robinson?
There were several locations. I'd have to refer to my report.
Okay, would you look at your report? And this is, it looks like report number or exhibit number 30. If we can pull that up just for the witness. Thank you, Kimberly. We had it for a minute here, a minute ago. Okay, if we could go to page number 2, please. Will you just list off the areas of that firearm where there was support for evidentiary support for inclusion of Tyler Robinson?
The swabs of the stock and grips of rifle, the swabs of the butt plate of rifle, swabs of the trigger and trigger guard of rifle with possible ridge detail / smudging, the swabs of the bolt of the rifle with possible ridge detail / smudging, and the swabs of the forend of the rifle.
We go to page 3.
Swabs of the barrel of the rifle with possible ridge detail / smudging, the swabs of possible ridge detail / smudging on the optical accessory.
And page 4.
The swabs of the protected underside of the receiver of the rifle after disassembly. The swabs of one 30-06 cartridge case. The swabs of one 30-06 cartridge. And the swabs of one 30-06 cartridge.
I want to ask you about a couple of those conclusions. Let's look at page 5, please. And calculation number 3, exhibit 1.3, do you know where that swab was taken from?
I'd have to refer back to page 2.
Can we refer back to page 2, please, Kimberly? Thank you.
1.3 is the swabs of the trigger and trigger guard of the rifle.
All right, going back to page 5. And we've had some talk, some testimony from you and some questions for you about the likelihood ratios. What was your conclusion as to the likelihood ratio that you analyzed in this question, in calculation number 3?
For this exhibit, the DNA profile was at least 1 trillion times more likely if it originated from Tyler Robinson as the major component and 3 unknown unrelated individuals than if it originated from 4 unrelated individuals.
You say at least 1 trillion times more likely. So it could be a much higher number than 1 trillion. Is that accurate?
It's possible.
But the protocols in your laboratory say you cap that at the number 1 trillion. Is that right?
Correct. We would not report a number higher than 1 trillion.
And it looks like you also did a probability statistic as well in paragraph E. Is that right?
Correct. It's another way of stating the likelihood ratio statistic.
And will you state your findings you made here in paragraph E, and that's on page 6.
The probability of an unrelated individual in the population who has not contributed DNA to the sample yielding this level of support is less than 1 in a trillion.
And same question there. The trillion number, it could be far less than that, but you stop your calculations or the statistics at 1 trillion. Is that right?
Correct.
Let us move to page 7 with regard to statistical analysis calculation number 7. Now, do you remember what 1.3 or 1.13 and 2.1 are?
I'd have to refer back to page 3, I believe.
You could jump to page 3. Thank you, Kimberly.
Page 4, sorry.
Page 4.
The 1.13 is the swabs of the protected underside of the receiver of the rifle after disassembly. And 2.1 is the swabs of one 30-06 cartridge case.
Now, did you do the swabs themselves?
I did not.
And 2.1 is a cartridge case. Is that right?
Correct.
And what's the difference between a cartridge case and a cartridge?
The cartridge is unfired. Cartridge case has been fired.
Right. Let's jump back to page 7. And what was your conclusion with regard to, well, first of all, why do you group these two together, exhibits 1.13 and 2.1 in your conclusions here?
They were both mixtures of 2 individuals, and they both yielded a likelihood ratio of the same magnitude, so they can be grouped together.
Okay. It's not that they were tested together?
Correct.
It's just that the results were of the same magnitude, so they were reported together. Is that right?
Correct.
All right. What was your conclusion as it relates to both of these as to the likelihood ratio?
The DNA profiles are at least 1 trillion times more likely if they originated from Tyler Robinson as the major contributor and an unknown unrelated individual than if they originated from 2 unknown unrelated individuals.
And did you make a conclusion here as well about the a probability statistic?
Yes, so the probability of an unrelated individual in the population who has not contributed DNA to these samples yielding this level of support, so meaning yielding this likelihood ratio, is less than 1 in a trillion.
Nothing else.
Mr. Rote.
The 1.3 sample is described as swabs of trigger and trigger guard, right?
Correct.
You didn't do the swabs, but am I correct that you have no way of knowing which part was from the trigger and which part was from the trigger guard?
Correct. So they were swabbed together, so I wouldn't be able to say where the DNA came from.
And that's one of the samples that was degraded, correct?
There were signs of degradation present in that sample, yes.
And you said with regard to that sample, that that was a sample consistent with at least 4 contributors, right?
Correct.
And did the what you term the major profile have the largest amount of degradation in that sample?
There was, yes,
And you can't tell us anything about when the DNA was deposited on the trigger guard or the trigger, correct?
correct.
You can't tell us anything about whether, when you say it's at least 4, it could be 5, 6, or 7 people with DNA on that trigger or trigger guard, correct?
Correct, which is why we have the major contributor that is suitable for comparison, and the minor contributor is not suitable for comparison due to that complexity.
And again, major, minor just has to do with the levels of DNA you were seeing, has nothing to do with someone being engaged in activity that is major in relation to the minor contributor.
Yes, so the major contributor is the majority of the DNA contributed to that sample.
Okay. And some of these samples, you have major contributors of more than one person, right?
Correct.
So for sample 1.1, swabs of stock, you have 2 major profiles, and there are at least 4 contributors on that sample, right?
Can I refer to my report?
Sure. It's Exhibit 30. Plaintiff's 30. Right?
You said Exhibit 1.1?
Yes.
Yes, it was a mixture of 4 individuals. There were 2 major contributors.
Okay. And again, with regard to all these samples, no way of knowing when or how the DNA got on those samples, correct?
Correct.
You referenced another statistic in your report, which is the statistic related to paragraph E, I guess.
Correct.
Is it what's called a random match probability statistic? Or is that something else?
It itself is not a random match probability statistic. It is a way to represent the likelihood ratio similar to a random match probability.
But it's still a likelihood ratio computation, right?
Correct. It's based off the likelihood ratio computation.
And it's still subject to all the limitations we've talked about.
Correct.
Can't attribute it to any person. Can't state it's infallible. Can't state there's a 0 error rate. And you can't state that it is a source connected with any one person, correct?
Right. So part of not being able to state source attribution is the reason we report the likelihood ratio statistic. It speaks to the weight of the evidence. And so yes, we can't do a source attribution, and we report that statistic and address that uncertainty that way.
And address the uncertainty along with the other limitations we talked about.
Correct.
Thank you. That's all I have.
Thank you. Anything further for this witness?
No.
All right. May this witness be excused? All right. Thank you, ma'am. You may step down. Anything further from the defense?
No, we have no further witnesses.
All right. Returning to prosecution, anything further?
No, Judge, we have no rebuttal evidence to present at this hearing. The state has no rebuttal evidence to present at this hearing. However, before we break, there is the matter that was discussed yesterday with respect to publishing in the courtroom Exhibit 12.1, so that the victim's family can observe that.
Thank you. All right. Do the parties wish to be heard as it relates to this briefly, and then the court will issue its ruling?
Your Honor, I actually just want to make a quick record. We have advised Mr. Robinson of his right to testify at this hearing, and he is choosing to take our advice and not testify.
Is that correct, Mr. Robinson? And I note that he's nodding in the affirmative. Thank you, Ms. Visser. All right. In regards to the outstanding issue about the publication of State's Exhibit 12.1 to the courtroom only, to persons here, any further input from any of the parties before the court issues its ruling?
Jeff and I, on behalf of the victim, my understanding is you ruled yesterday that you were going to play it, that you did grant our request. So I don't know if we.
Thank you.
Judge, I might simply add, given the court's ruling this morning with respect to displaying exhibits, we may want to make a record with the live streaming folks here that it's not going to be published.
Thank you. All right. Nothing further from any of the parties? Okay. I'm just updating some notes. All right. The court wishes to readdress yesterday's ruling in light of this morning's sanction as it relates to Exhibit 16. The court separately addressed that incident and imposed a sanction on the record. Having considered all applicable public access, fair trial, privacy, and victims' rights interests, the court adheres to its prior ruling. The court finds that temporarily limiting live stream to audio only while Exhibit 12.1 is displayed is necessary to prevent the inadvertent publication of the exhibit from being transmitted to outside the courtroom, and no broader and is taking the least restrictive means to accomplish what is being requested. Accordingly, Exhibit 12.1 may be viewed by all persons physically present in the courtroom, including victim representative Ms. Kirk in her capacity as the victim representative. The same in-court viewing rules applies to all parties and courtroom attendees. And that is the ruling of the court. Let's go ahead and proceed to that, to the state. So could the camera operator let me know when we're switched to an audio only? We are? Okay. All right. And as it's switched to audio only, to the state, now my understanding there's no audio on this surveillance on 12.1. Is that correct? All right. All right. So let's go ahead and play that. And I'm going to rule that this also applies to the still photographer. It cannot be captured the screen in any way. I noted video recording, but I intend as well as no still capture of any of the monitors during the publication of 12.1. All right. And to the state, just let me know if you're ready. Let's go ahead and play it now.
All right, y'all. I am out of here. They're cutting off video. They're cutting stuff off. There's no scenario or information on whether they're going to ever have any other conversation with Lance Twiggs. I'm pissed off. This is not what I expected. So I'm just going to cut the stream here, and because we're not getting anything. Okay. So I want to say thank you guys for being here. And I want all of you to go straight over to Trigger Smart's live stream or Valhalla's live stream. I don't know who else is live right now, but make sure, excuse me, to go over to their live stream right now. So go to Trigger Smart or either Valhalla VHT, and I will talk to you guys later because they're not doing anything. And now they just cut video. So we're just going to be staring at a freaking crest on a wall. So I'm sure they're going to keep going and just sit there and stare at the crest on the wall, but I'm not doing it. I was expecting this to be Lance Twiggs Day. So I'm out of here. Talk to y'all later, and go straight over to Trigger Smarts and Valhalla, and make sure to hit the like button here, hit the like button, and hype this video. Talk to y'all later.